necessary. It has to be admitted.
My lord.
Heard? Heard? Admit. Issue notice to the respondent by both ways. Fixing কালটা যে ডেট করছে 27/8/2024 for filing of written statement and settlement of issues. Release this matter on 27th August.
May I pray one more thing? The advocate B Das name may be reflected as who in the Wakalatnama his name is there, but in cause list his name is not there.
The name of
B Das. Bhavasis Das.
Devasis.
Bhavasis Das.
The name of Sri Bhavasis Das, comma, whose name the name of Sri Bhavasis Das be reflected in the cause list as his name is included in the list of advocates in the Wakalatnama filed by the petitioner. Yes.
Grateful, madam.
Item number 2, fresh admission. This is a transfer of civil proceeding.
Yes.
From family court judge to Kotak family court. I am from family court number 2 to family court Kotak.
From Bhubaneswar to Cuttack.
Yeah.
I don't allow Bhubaneswar to Cuttack.
My lord, there are two proceedings are pending before opposite party data proceeding se appeal करछन गोटे
Cuttack Bhubaneswar ভিতরে কিছু ডিফারেন্স নাই আজ্ঞা
the petition is remote area রହୁছে
রিমোট এরিয়া বলে
about 70 kilometers
কোটু
one Bhubaneswar
70 কিলোমিটার কোন জায়গাটা কোন আছে
Pattapur that is
সো
ସେ ତାର ମେଲ୍ ମେମ୍ବର କେହି ନାହାନ୍ତି ଇଣ୍ଡିପେଣ୍ଡେଣ୍ଟ ଇନକମ୍ କିଛି ନାହିଁ ସେ ଆଜି ଡୋଣ୍ଟ ନୋ ମେଲ୍ ମେମ୍ବର
ତ କଟକକୁ ଆସିଲେ କେମିତି ସୁବିଧା କେମିତି ହବ
କଟକରେ ସିପିଟା ପେଣ୍ଡିଂ ଅଛି
no
ଆଉ ଗୋଟେ ଜିଆର କେସଟା ପେଣ୍ଡିଂ ଅଛି
sorry considering the grounds cited I am not inclined to entertain this application which is therefore dismissed. Yes.
Item number 3.
Not item number 3. Last occasion, the State Council took time to file counter.
Well, in this case, we have received a Parabage comment, and this is a
Last
case
time
of
also they received the Parabage comment.
Last time also was there.
Within a week, my lord will file the comment.
Release this matter next week as prayed for by Lawrence State Council.
Yes.
Counter affidavit, if any, be filed in the meantime, failing which the matter shall be disposed of on the basis of available pleadings.
Only interim order to continue.
Interim order to continue.
item ଗୋଟେ withdraw
Permitted to withdraw. Item 2, hala? Permitted to withdraw. Yes.
Item number 4.
I am the Gram Rozgar Sevak Kamal.
Yes.
I appointed on 21/2/2018 by Minister 1. But wrongly the date of appointment was inserted in the gradation list. So, your lordship see, Minister 1 is 21/2/2018, page 9, your lordship.
Yes.
Subsequently, when the gradation list prepared, your lordship, page 21, my item is 172, they have entered 24/2/2018. So the video
Give objection.
Yes, my video has given a letter to the government, and government has also written to the collector, your lordship, Minister 6, page 26. They are not doing it. As a result, I have been deprived of selection in the accountant cum DO. Page 26, your lordship, page 26, Minister 6. The government has also written to the collector for correction of the joining or date of Sri Sashikanta Pradhan, GRS Udaipur under Noagam block.
Where is that? Where is that order?
My lord, page Minister 6, page 26. To the collector. Collector has not done it. As a result, my lord, Minister 7, I was deprived of the
All right.
selection from the as per the guidelines. After 5 years.
At that stage, you should have come to the court before this office order was issued.
My lord.
Because that's only a one-time absorption.
No, my lord, several posts are still vacant. Minister 7.
I don't know.
Yes,
As per
my
the
lord,
rules.
given.
I think you were referring to a rules in that accountant cum data entry operator by way of a one-time measure, they will take those 30%
Yes, yes, my lord.
Instead of
30% quota
Oh, yes, my
of
lord.
the Gram Rozgar Sevaks.
Yes, my lord.
It will be 30% will be filled up.
No, not filled up. That's why I have given a.
Sir, listen, sir. You go through that rules minutely. Recently, I passed a judgment. I have interpreted the provisions of the rules. First, there has to be a one-time measure. for absorption of the existing Gram Rozgar Sevaks who have fulfilled the criteria 5 years and all that. Thereafter, they will make selection.
Yes, ma'am. Because your lordship knows, because of their inadvertence or their.
That's a different matter. That's a different matter.
Why should I suffer? My junior has got.
Sir, you don't understand what I'm saying, sir.
Yes, ma'am.
Please try to understand what I'm saying. I'm not saying that you cannot now claim this is purely a question of absorption.
Yes, ma'am. Madam.
You are saying that there are posts are vacant. They may not be very relevant insofar as you are concerned because this is you got a year pursuant to this.
Yes, ma'am.
130 numbers of Gram Rozgar Sevaks of this they are hereby absorbed. So what will happen is the subsequent vacancies they will fill up through selection. That is the problem. Anyway, I will direct the collector to.
My junior appointed.
All right. The petitioner was appointed as Gram Rozgar Sevak as per engagement order issued on 21/2/2018
Madam.
by the Sarpanch of Gram Panchayat,
Soroda.
Soroda Gram Panchayat. His grievance is that in the gradation list
My lord.
prepared
172, your lordship, right? 172.
Please don't interrupt, sir. I feel very irritated if somebody interrupts me while I'm dictating that order.
Yes, sorry.
Kindly wait, sir. If there is any factual error in the order, you can bring it to my notice. I will be the first person to correct it. But in middle of my order, you are interfering.
Sorry.
A draft gradation list of Gram Rozgar Sevaks of the Gram Panchayat was prepared on 7/8/2020, wherein the petitioner's date of joining was shown as 24/2/2018. The petitioner brought the said fact to the notice of the BDO, who, after going through the records, recommended to the government for issuing, sought for necessary clarifications from the government. The government in PR and DW department, by letter dated 29/6/2024, directed the collector to take necessary steps at his level as per recommendation of the BDO regarding correction of the joining date of the petitioner. The petitioner's grievance is that despite such clear instructions of the government, no action whatsoever has been taken by the collector till date. As a result, he has been deprived of the benefit of absorption of the existing Gram Rozgar Sevaks as per order dated 26/6/2024 of the Jila Parishad Nayagad. Having regard to the innocuous nature of prayer of the petitioner, this court deems it proper to dispose of the writ application, directing the collector, come CEO, Jila Parishad Nayagad, to act upon the instructions of the government as per letter dated 29/6/2024, and to take all necessary steps as per recommendation of the BDO for correction of the date of joining of the petitioner as early as possible, preferably within a period of, let us say, within a period of 2 weeks from the date of production of certified copy of this order by the petitioner. Yes.
Item number 5. May I please?
Yes, so that's the last order.
Yes.
Well, in terms of the lordship's direction, my lord, in this case, with respect to production of a particular file and the failure on the part of the concerned director of higher education to produce that particular file, you are directed to appear in person.
Yes, produce the file.
My lord, we have filed an affidavit, my lord, enclosing the documents, my lord, that despite a source team has been specifically formed for this specific purpose, but despite all sincere effort, my lord, the file could not be traced.
There is some hanky-panky here. They are deliberately suppressing the file for some reason. Why will the court not feel like this?
Person is very much available.
No, no. And who is he? He is the in charge. There is no regular director.
Next.
There is no regular director.
Next. Mr. First July join. Just additional charges.
Oh, that doesn't matter.
And on the previous occasion also, my lord, we have been instructed through a letter also, my lord, that we are still searching the file. And that is why after taking note of the same, the lordship had directed this. But
Personally, I'm sir present Roy with resolution. Personally, our deputy director and Muhammadan sir personally
File vanish. How can a file, a government file, how can it vanish? Unless there is some foul play involved. It appears that it is being deliberately suppressed from the court.
we will try our level best further, my lord.
No. I will not accept this affidavit. I will not accept this affidavit. But nevertheless, since he is not the regular person, I will pass necessary, I will draw adverse influence. That is the only thing that can be done. He is not the. What have you said? Pursuant to order dated 9/7/2024, Dr. Dharanidhara Nanda, working as the director, higher education in charge. There was somebody, some director was there. Last time he had come.
Sir, he's retired. Bhavani Charan, Dr. Bhavani Charan.
Director higher education in charge is present in person and files an affidavit inter alia stating that after receipt of the orders of this court, a team of 5 officials was formulated entrusting the responsibility of conducting thorough search to trace out the appeal file of the petitioner. The said team, after thorough search of the index register, observed that the appeal file bearing number 6 capital C hyphen Roman 3 hyphen 19 hyphen 2010 finds place in the said register of 2010. It is further stated that the members of the team conducted vivid search of the records in the Higher Education Department Directorate on 11/7, 12/7, 2024, 15/7, 16/7, 18/7, 19/7, and 27, 2024, but could not trace out the file. This court is unable to accept the stand taken in the affidavit. Stop. It is highly surprising that the particular file sought for by the government, sought for by this court, is missing. in any case, this presents a very sorry state of affairs in the office of the director. Stop. Though learned State Council requests for further time, this court is not inclined to grant the same. The writ petition being of the year 2012 shall be heard on its own merits, and if necessary, appropriate adverse inference shall be drawn against the state for non-production of the relevant file. So, a copy of this order be communicated to the Chief Secretary Odisha for taking note of the affairs existing in the Director of Higher Education, and to take stern action against the persons found responsible. A report in this regard shall be submitted to this court within 4 weeks. Stop. The affidavit be kept on record. The personal appearance of Dr. Dharanidhar Nanda is dispensed with for the time being. Yes. We'll take it up. Let's this matter. Yeah? On 3rd September. Ajilim chalchi. बुझिला क्या High Court को ऐसी कहउछन त चिंता करी कि कोन
मु सर खोजली त सर मु तर आउथरे सर खोज
फाइल बजी जाए गवर्नमेंट मूवी गवर्नमेंट आज्ञा 3 वर्ष लॉ सेक्रेटरी हो कि मत पाठ पढांत नहीं
सर मु सर नुआ
किछ कोन ते yes
My lord, 3rd September.
3rd September.
Obliged.
Let the chief secretary look into it.
Obliged.
My lord, for communicating the same, a free copy of this.
Yes, a free copy of this order be handed over to Sri Patnaik for compliance.
Obliged.
Item number 6.
My pleasure, officer.
Yes.
In this case, my lord, the petitioner having possessed the qualification of a diploma in special education applied for the post of a Shiksha Sahayak, my lord. And he got selected, and at the time of issuance of posting order, the government, my lord, held up their posting order on the ground that whether the diploma in special education is equivalent to city or not. That will be.
This was heard earlier.
Your lordship heard this matter. A short fact, just I am saying for lordship matter.
No, you were engaged as Shiksha Sahayak.
Engaged as Shiksha Sahayak.
Acha.
What happened thereafter, my lord? But that government took final decision for giving engagement as Shiksha Sahayak. But since there was a delay, my lord, petition earlier after this honorable court directed to the collector to consider the case of the petitioner. Collector passed order, my lord, saying therein that the post for the Shiksha Sahayak kept reserved since the government that clarification is pending for the government, my lord. Thereafter, government clarified that is equivalent to city. But engagement order could not have been issued. That is why the petition after this honorable court, my lord, in this writ petition, my lord, seeking direction to the opposite parties to issue engagement order, effecting upon engagement from 2006. Since they have equivalent, they have a qualification is equivalent to city, and those persons engaged
in the equivalence order. Is there any order?
Equivalence order
acknowledging the equivalency.
They have stated in the counter affidavit in the year 2012, my lord, government board second education.
So what is the problem then?
Problem, my lord, got appointment, but the engagement was not effected.
So that was prospectively
that has been effected, but not retrospectively, my lord. In the similar circumstances, my lord, this Hon'Ble Court, prior to declaration of by the board in the year 2012, my lord, it is this qualification equivalent to city. This Hon'Ble Court in one case, my lord, those were appointed in between 2005 to 2007, my lord, they approached this Hon'Ble Court on the similar issue, my lord, and this Hon'Ble Court held that no, the qualification is equivalent to city. That judgment I have
Yes.
brought, my lord. And here, my lord, petition not claiming any financial benefit, only seniority, my lord, because since Lordship knows, my lord, after 3 years of completion of service, they shall be treated as a junior teacher. Thereafter, they shall be treated as a government primary school teacher after 6 years, my lord. And in the meantime, my lord, because of the prospective effective of engagement, my lord, they are deprived of getting the seniority, my lord. That is only the issue, my lord, for education, Lordship, my lord.
Yes. What is your case?
Our case is that, my lord, the case was filed in the year 2013. And the equivalency status, my lord, it was introduced in the year 2012. So, my lord, after the equivalency status was determined, previously, my lord, there was a restriction that were not equivalent. And thereafter, my lord, that has been superseded, and prospectively it has been decided that it is to be equivalent.
Yeah,
and that is one
I
of
would
the-
like to know, because what by equivalence, what you are doing is you are only declaring that these two streams are equal.
Yes.
So the question of prospectivity or retrospectivity, would it apply here?
No, my lord, because there was a denial of
You are
equivalence.
acknowledging something which is already there.
My
You
lord,
are making something explicit which is already implicit.
my lord, our submission is like this, my lord, that there was previously a denial that it is not
Where is that? Where is that? Let us go through the documents.
My lord, I'm just making
Yes.
actual, my lord, I'm making an oral submission. That, my lord, I will take a lordship to the documents with the lordship permission. In the year 2010, my lord, there was a restriction. In the year 2012, my lord, thereafter, the equivalent status was determined. The petitioner was offered with an appointment thereafter. Because she was engaged somewhere else, she could not submit her joining report, and she could not report for joining because she could not relieve from the previous station. So in this process, she appeared before this Hon'Ble Court. And in this case, there was an interim order that without affecting her right to get a seniority, she may be permitted to join. Now, when she produced that particular interim order, even if, my lord, after a period of 1 year, her joining report was accepted, and from that date, she has accepted her joining with all the terms and conditions, whatever it is available in the order of appointment. She had never disputed her order of appointment. Thereafter, she also got the status of the junior teacher. Taking into consideration that date is the prospective date. Now, my lord, our stand is that, my lord, since prior to 2012, there was no document prescribing the two qualifications to be equivalent. And that is one of the mandatory requirement in the advertisement, that a person should have this much of qualification or equivalent. So in absence of the same, prior to 2012, she cannot have
This is a
a
technical view.
But
This is a technical view.
that is one of the document which is
Yeah,
required.
no, I'm
My lord,
saying that.
And my lord,
You
with
may have
respect to
a,
the decision, my lord, with respect to the decision, what my lord senior is actually referring to in that 2005 to 2007. There, my lord, the issue was something different. Persons were issued with an appointment. Later on the basis of one clarification, they were issued with the so-called notices for termination. So they approached before this Hon'Ble Court in the year reported in the year 2012 December. They are taking into consideration the correspondences in the documents issued way back in the year 2005. But decided that this certificate can be held as the equivalent certificate. For that reason, the issue of these so-called notices are valid. But here in this case, my lord, the petitioner had never been offered with an appointment. On the basis of not having the equivalent status, she was never offered with an appointment. For the first time, she got the appointment order in the year 2013 and she joined in the year 2014.
No.
No, I'm basing upon the documents, but I can say that if the petitioner has got the appointment,
you have enclosed engagement order under Annex A/3.
Yes,
My lord.
that is of 2013.
2014.
My
This is after that.
Yes, ma'am. No, my lord. Copy of the letter, yes. No, my lord. She got the we issued the engagement letter, my lord, on June 2013.
Okay.
And she made a representation on July 2013.
Sir, where is that?
My lord, it is in the additional counter affidavit dated 15/3/2023, my lord.
Pursuant to order that they communicated to you, where you are hereby instructed to report at DPO along with all original certificates. Yes.
And my lord, this annex of A/3, my lord, this is 24/6/2013 and 8/7/2013, my lord. These are the letters which are issued to her for execution of the agreement and to engagement letter, my lord.
Yes.
And there
this is the first letter.
Yes.
Yes.
And my lord, this is after getting the equivalent status, my lord. That is what we have stated. And annex B/3, my lord, page number 9, page number 9, my lord. That because she was facing some resignation problem and she could not resign from the previous organization. That is why she sought for some time, my lord, for extension of her joining. And that was on 20th July 2013. That authorized, we have also taken a stand, my lord, that authorized says that she was in alternative employment in other capacity. And she could not join even within the due time when we offered her the appointment. Now she claims that in this particular post she should get the retrospective appointment. This is also an additional ground, my lord, what we have stated in our letter. And my lord, thereafter, with the lordship's interim order in this case, my lord, she submitted her joining report on 19/9/2014. That is annexed to C/3.
Annex?
10 or 10, my lord.
Page number 10 of your counter.
My lord, that document just now I referred to.
Additional affidavit. Okay.
Additional affidavit.
19/9/2014.
Yes, my lord.
Yes.
She expressed her willingness to execution of the agreement and to submit the document, and the interim order granted by this honorable court, my lord, on 16/9/2014 in miscase number 7542 of 2014. It is at page number 13. In this case, my lord.
Our question of her seniority shall be subject to the result of the application. No course order.
Yes. So, my lord, when she produced this particular letter, even if, my lord, she was issued with the offer of appointment on 8/7/2013, but her appointment was accepted on 19/9/2014 because she was facing some resignation problem. That is what this time.
No, Mr. Apati, I would like to ask you, if you were engaged elsewhere, your joining in this post or of Sikha Sahayak is contingent upon your resignation from the previous post. So how can you retrospectively claim that your seniority in this post?
No, what happened, my lord? Prior to selection of Sikha Sahayak, my lord, she was engaged as a resource teacher.
Block resource teacher, yes.
Block resource teacher, my lord. Prior to selection, prior to 2006, my lord. But the event of issuance of engagement, my lord, should have tendered resignation from that post, my lord. But because of a dispute arose, my lord, she did not.
That is the problem.
My lord, did not.
That is a big problem. Because what will happen, supposing you are claiming retrospective joining with effect from?
With effect from 2006, my lord.
2006. By such time, admittedly, you are a BRCC.
Yes.
That becomes difficult. We'll find out.
So far as the monetary benefit, my lord.
I understand. It's notional. Even notionally can it be done?
Yes.
Because this will mean that you were engaged as BRCC actually and notionally as Sikha Sahayak in 2006. That concept. I don't know.
Schematic post, not a regular.
I don't know. Maybe.
For sustaining
that. Closing it.
Under the similar, just I am placing one regional term.
Yes.
Under similar circumstances, those who are not engaged previously, my lord.
Yes.
But because of this dispute, my lord, they were given engagement, my lord, prospectively. But their seniority was counted, my lord, or retrospective, my lord, from date of selection was made, my lord. Lords, you can have a glance. My regional affidavit, my lord.
I'm looking at it.
Draft repeat. List of 10 errors you can have a glance.
Yes.
Here, my lord, part my senior is my brother is submitting for lordship, my lord. Page 11, lords, you can for movement, my lord. Lords, you can have a glance. Page 11, annexure 10 series, my lord. Here, my lord, lords, you can have a glance. The bottom part. Diploma in special education. They were given a engagement in the year 2005. Left side, my lord. The
Yes.
bottom. So that diploma in special education was declared as equivalent as city, my lord. The 2005. They were given engagement and they were regularized after 6 years. After 3 years as a jetty, thereafter from 2012, my lord, they are regularized as a primary school teacher, my lord.
I don't know. Only in your case, there seems to be a difficulty that the date from which you claim initial engagement that coincides with your service as though not a service but as engagement as a block resource teacher.
My lord.
How can a person hold two posts?
Because what happened? Because
How can a person hold two posts even if notionally?
Suppose, my lord, in the just after selection was made, my lord, they are placed in the select list, my lord, and other persons were given engagement, my lord, in the 2006.
I understand, but you are claiming parity. I understand,
but the event, my lord, engagement order issued, my lord. Suddenly, the petitioner would have tendered resignation and joined.
I would just like Mr. Patnaik to respond to what he has said about this last person, that Kailash Chandra Maharana.
Annexure 10 series, my lord. Your lordship had granted me an opportunity to give a clarification to that one. So we have filed one additional affidavit to that effect against this annexure 10. My lord, these are the appointments of the year 5, my lord. My lord, these appointments which were made with the TAC qualification, my lord, in the year 2005 to 2007, those were the matters, my lord, taking into consideration the clarification issued with respect to equivalency by the Women and Child Development Department. The appointment orders, engagement orders were issued, and later on, my lord, they were issued with the so-called notices. And they appeared before this honorable court with respect to that previous recruitment, my lord, not with respect to this recruitment in terms of annexure 2006 resolution. This is out of this 2006 resolution, my lord, this advertisement, my lord, nobody has been offered with an appointment. It was with respect to the previous appointment. They were issued with the appointment on the basis of the equivalency, and they were facing that particular so-called notice of retrenchment. And that has been clarified in this particular decision, my lord, what I don't see is relying upon the decision rendered in the year 2012. But, my lord, here in this case, in the present case, my lord, the persons were not offered with an appointment, engagement. And after getting the clarification of equivalency in the year 2012 only, they were issued with the engagement orders. It is not only with respect to these two petitioners.
All right, shall we close it?
Yes,
Well, only one document there.
Yes.
Annexure 9, same. Annexure 10, I have placed with lordship. Annexure 9, my lord, same regional, my lord. But my friend, my lord, placing for lordship in the year 2006, nobody got appointment having qualification or diploma in special education. Annexure A, my lord, annexure my lord 9, page 8, my lord. In respect of Jajpur district, my lord, in the year 2006, this person, my lord, having diploma in special education got appointment. And annexure 9, my lord, same Jajpur district, in the year 2006, they got the appointment of the my lord, having qualification of diploma in special education. Thereafter, what happened, my lord? Let's kindly have a glance. The 10 series, what I have, my lord, annexed with this region, my lord. Let's see, can have a glance. Page 16, my lord. This is not the case of diploma in special education, but for certain region, my lord, their engagement was held up. Because of fault of the opposite party, the selecting opposite party, my lord. And it's page 16, my lord, they gave engagement in the year 2011. But what they have stated, the engagement shall need renewal with effect from 1/6/2012 because of an agreement, execution of agreement. And the seniority of Sri Amar Kumar Jaya Singh hereby placed below 236 batch of Shiksha Soy of respective blocks under Khordha, Bhubaneswar Education District. Because of some other reason, not deploying special education, their case were pending, but they are given engagement in the 2011. But they have given the seniority, my lord, from 2006, my lord. Next, my lord, page, let's see, page 17, my lord. This is also same in respect of Khordha district, my lord. Engagement, this was issued engagement order in 2011, pursuant to order of the Hon'Ble Court. Engagement shall need renewal with effect from 1/6/2012. But my friend, my lord, some people lords, since the agreement was executed in the year 2014, my lord, that cannot be retrospective, having no retrospective effect, my lord. But here, my lord, execution of agreement was in the year 2011, and that renewal date was 1/6/2012. But the seniority of Sri Binodini Sahu is hereby placed below 2006 batch of Shiksha Soy. Though engagement order was issued in the year 2011 and execution of agreement was carried out, my lord, on 1/6/2011 and renewal date was 1/6/2012, her seniority was counted from the 2006. Because of the fault of the, my lord, the opposite party, my lord, petitioner is being suffered and is being deprived of getting her seniority, my lord. And in my respect to submission of lordship, since prior to the selection, my lord, she got engagement as a block resource teacher. And since she could not have been given the engagement order, she did not tender her resignation. In the event he got the order of engagement, suddenly she must have tendered resignation and joined the post of Shiksha Soy. And then, like others, my lord, her seniority must have been counted from the date of engagement, my lord.
I don't know.
That's all.
Call it. I'm closing it. Yes. Hearing concluded, judgment is out. These are matters, there are two matters.
Same. The same.
I do not 7.
There are two matters tagged in this.
Three matters. I'm sorry, there are 3 matters, Your Lordship. So far, the first matter is concerned. Petitioners, they are the selected candidates pursuant to an advertisement published on 30/6/2018 under Annexure 2.
Selected candidate means candidate as
GRS.
As GRS, Gram Kriya
GRS.
Sevak, Your Lordship. I beg apology. At page number 16 was the advertisement. The 19 vacancies were there. 19 persons have been found in merit list. Now, subsequently, we have filed this application that pursuant to the merit list, we have not been appointed. We have not been issued the appointment letter. In the counter affidavit, we came to know that this another matter is a second sub-item filed by another candidate who belongs to Yuva category. He has filed that application, challenging the advertisement, and then operation of stay is there, Your Lordship. For that purpose, 3 matters is there. I'm sorry if I have interrupted you. That is
so we'll have to hear that matter first.
Yes, that
Yes.
is what I was pointing out.
13017.
131.
My lords.
And your lordship have already had that matter on the last occasion. After hearing my learned senior appearing for the first matter, Mr. Rautre, my lord, I was had in this particular case. Still, my lord, I have to just recapitulating your lordship's memory. But this is a case, if your lordship holds this brief, my lord.
Yes.
This is a case where the petitioner is a UR category candidate belonging to Sonpur district. What he challenges in this writ petition is the issuance of advertisement under Annexure 3 and the guideline under Annexure 4. Why it is so, my lord? The advertisement was issued relying upon that guideline That is why both guideline as well as the advertisement is under challenge. And the grounds on which the advertisement was under challenge is, your lordship kindly come to the impugned advertisement at Annex 3.
Yes.
My lord, running page 15. Your lordship kindly mark, the advertisement is dated 30th June 2018 and it reads like this. Application are invited so and so for contractual engagement of Gramya Rojugar Sevak GRS under MGNREGA. So the first point I want to converse over here is, the post in question is not a civil post. It's under a scheme. And next point what I want to convey before lordships here is serial number 3. The total number of vacancies advertised are 9 and all the 19 posts have been reserved. So there was a 100% reservation in favor of.
I think that they have clarified. That
Right.
it is because of the spillover. I mean, they have taken over. What is it called actually? I'm forgetting that word.
Now, previously, my lord, it was a single post. Now, thereafter, my lord, it has been become a district cadre. So once it is a district cadre, then the total cadre strength has been taken at the unit, not at the single vacancy.
All right, let him.
Well, so here the point is, if at all an advertisement is being issued, it
I
can.
think that Nagaraj says post based and not vacancy based.
In no case, in a recruitment year, when the advertisement is issued, the total number of posts, the ceiling limit of 50% can be exceeded. If at all that is done, the probable contingency will be that will amount to reverse discrimination under Article 14 and 16. Because here is a case, my lord, I belong to your category, and even if there is an advertisement in place issued by the state agencies, my lord, I have got my right of making an application and consequential consideration as has been guaranteed under 15(1), 16(1) and 2, everything has been violated. Because it says, my lord, nobody can be discriminated on the ground of caste, so and so, your lordship knows better, I need not reiterate. So here, my lord, the first point is 100% reservation. Second point is whether they can.
Just a moment before we go to that. So 19 posts were advertised.
Man,
What is the total cadre strength of the district cadre? What is the total strength?
well, that I will explain, my lord. You lordship kindly come to when this decision was taken, making it a cadre. That is important. That is why the guideline is under challenge. You lordship kindly see, the posts were created in the year 2017. That they themselves have admitted in their counter. I will straight away take your lordships to paragraph 6 onwards at running page 33.
Yes, place it.
My lord. My lord, sorry, paragraph 5 onwards. Sorry, paragraph, sorry.
So this Gram Rojugar Sevak is to be appointed one per each Gram Panchayat.
Well, because, yes, ma'am. It well, so till 2018, till this impugned guideline came, posts were a single cadre post. Accordingly, there was no reservation in view of that faculty association case, because once a post is, unless it's a multiple post beyond 3, you cannot apply this. Yes, ma'am. So your lordship kindly come to paragraph 5. Well, they themselves have admitted multi-purpose the assistant, namely GRS, are engaged on contractually in each Gram Panchayat for the execution of work, which is co-terminus with MGNREGA scheme. The finance department concurred the creation of 6,234 posts of GRS for the entire state in the year 2014, and after for reorganization of Gram Panchayat in the year 2017. Finance department again has concurred the creation of 567 new posts of GRS by increasing total number of posts to 6081. So posts were created in the year 2017. When the posts were created as a single cadre post in the reconstituted the Gram Panchayats, reorganized Gram Panchayats, not in a district cadre. One. Second thing, you lordship kindly see. Thereafter, with regard to Sonpur district, they have straight away mentioned in para 6. In the Subarnapur district, there was 96 Gram Panchayat which were functioning prior to reorganization of Gram Panchayat in the year 2017. That consequent upon reorganization of Gram Panchayat in the year 17, Suvarnapur district is functioning now with 109 Gram Panchayat. Now you Lordship, kindly calculate 96 were there, 109 Gram Panchayat have been created. So what is the shortfall? What is the addition? What is the addition? There, my lord, it comes to 13. 96 and here 109. So only 13 were created. My lord, but keep it in mind. Thereafter, your advertised is 19. Advertised is 19. Then your lordship may kindly come to para 8. Para 8. That with regard to the contention made in para 1, it is humbly submitted that GA and government in PR and DWO department dated 6/4/2018. That is the guideline. So when the posts were created, it was a single cadre post. Issued a comprehensive guideline. It's a guideline for selection of engagement of GRS under NGNRAGS. The aforesaid guideline by procedure selection point number 2 at page 3. This is available at page 21. I will take your lordships to. Stated that ORV Act 1975 and rules formulated thereunder shall be strictly followed, and the post of GRS has been declared district cadre by the guideline mentioned above. So in the year 2018, the post have been declared as district cadre post. The total cadre strength of the GRS in Sonpur is 109. Out of that, only 9 SC, 19 UR and 50 SCBC persons are in position. Now the point which requires your lordship's consideration is it within your domain to categorize the persons who are already in employment on the basis of their birthmark when you had not done prior to this? When you
doing it for as if to fill up the shortfall vacancies.
Yes, this very decision is taken, which is given in the impliedly retrospective effect. The decision now they are making it district cadre and applying this ORV Act, it virtually gives it retrospective effect by making the selections which were made all these years against a single post without following the reservation principles. Can they do that? This is a big question again, my lord. Next question comes, my lord, when they are saying ORV Act is applicable. They are saying that they are adopting by virtue of a guideline. The other day I had taken your lordships and I am requesting your lordship to kindly come to the ORV Act. If at all the book is there.
No, ORV Act.
SC/ST manual.
SC/ST manual right.
SC/ST manual is there. Achha. My lord, may kindly come to. My lord, I will just point out only relevant portions. I will not take your lordship's much time. The very act itself made for civil post under the state. Civil post under the state. My lord, your lordship kindly. I am requesting your lordship kindly keep it in mind. The act itself is made for the applicability for the state, the civil services and posts, and thereafter your lordship kindly come to section 3, applicability. This act shall apply to all appointments to the post and services under the state, except D, those filled up on the basis of any contract. The advertisement in place I have shown to your lordships is on contract basis. So the applicability of the act, which is an act of the state legislature, specifically excludes contractual appointments. Now the question is, what will happen? If at all, my lord, it is within the domain of the state to extend this benefit of this the act or coverage of ORV Act to contractual appointments, the best course would have been to amend this ORV Act. In absence of an amendment, by way of a competent state legislature, can, by way of an executive instruction, the otherwise fixed applicability under a statute, under the act of the competent state legislature, be dilated. That amounts to overriding an act of the competent state legislature by way of an executive instruction. And your lordship knows, my lord, what is the status of a guideline? Guideline is still inferior so as to come within that ambit of 162 of the Constitution.
All right.
Now you may kindly see two things, my lord, I want to point out. Again, I was at para 8 of the writ petition as per page 30, counter affidavit at page 34. This is where they have retrospectively done this, they could not have done. There is a deficit of, my lord, this application of post-based roster to all those posts which were previously filled up without application of reservation is itself a wrong action on the part of the authorities, because they could not have done so. That amounts to categorizing a person by a place of by a birthmark, because he is born in that particular cadre, irrespective of the fact whether he had competed on merit or not so as to be selected. Now you are categorizing him against a particular reservation category because he belongs to a particular category by birth. So if at all this exercise done by them is wrong, then the consequential action in identifying those 19 posts as shortfall vacancies made year back for those reservation categories and putting them to advertisement.
So, but why are you challenging the comprehensive guidelines?
Because, my lord, in the comprehensive guideline, you must kindly see.
It simply says ORV Act shall be followed.
Yes, but that gives them the handle.
That also gives you the handle. Just now you have pointed it out.
No.
You said that as per the ORV Act, it does not apply to contractual engagements.
I am your category person, but I have got no edge to grind against whether there is a reservation or not. Because they are doing it, because, my lord, as your lordship may kindly see, till this advertisement was issued, making these posts identifiable and reserved or allocated in favor of these reserved categories, we have the right of being considered.
No, Mr. Mahanti, sorry, you may have a point when you say that initially you have engaged them against one post each, which did not have any reservation, which could not have had any reservation.
Minor.
Correct.
Minor.
So, in view of the creation of the posts,
minor,
what according to you they have done, and also it appears like that, they have clubbed all those posts together and made it a cadre. And then, depending on their
they have, that is what they have done is.
I'll ask you to pause for a moment. I'll ask who's appearing, Mr. Das or Mr. Patnaik? Yes. Can you do it, Mr. Patnaik?
With respect to applicability to the ORV Act?
What they have said, their entire justification is that, nothing beyond that. So I have challenged both and let them answer. I will have one more point. If at all your lordship permit, I can take your lordships to. They themselves in their counter, by providing justification, they have referred to Annexure B/2.
Village level workers.
Village level.
Bhartan, I would have said that. Accountant of data entry.
I have dealt with that.
Sir, page 38, sir,
30?
38. This is the justification they are offering. Page 38 of their Annexure B/2. But sorry, I may be wrong.
The internal page.
Internal page 16 of their account.
This is the Gazette notification.
This is the Gazette notification.
26 March 2013.
Well, so they say that as because clause 2, rule 2, sub-rule 2, this is amendment rule, sub-clause 2, 30% of the vacancies shall be filled up by selection from among the GRS. We want to induct people by confirming the same to ORV Act. My lord, now your lordship may kindly see, I will request your lordships kindly mark the previous clause. 70% of the vacancies shall be filled up by the direct recruitment in accordance with Rule 9. So 70% direct recruitment, 30% by way of promotion, that means by way of selection, that is a promotional mode. Now your lordship was seeing the SCST manual, your lordship kindly come to section 4. Section 4, second proviso. Provided further that there shall be no reservation of vacancies to be filled up by promotion where 1. The element of direct recruitment in the grade or cadre in which the vacancies have occurred is more than 66 and 2/3%. Here the direct recruitment element is 70%.
No, this is for promotion. This is not a promotion. This 30% is not a promotion. By way of absorption, followed by selection.
No, that
I've
is
seen that very clearly.
that is what again they have said by way of promotion. That I have seen that.
But this is not a promotion. We have to interpret the rules as they are.
Come to page 50.
No, we have to interpret the rules as they read. We can't.
My lord, your lordship, they are referring to page 50.
What is this rule?
My lord, this is the Panchayat Raj deed of, my lord.
What is this rule?
My lord, this is the instruction imparted on the relying upon they have done it. This is
What rule is this? Let me just see. It is 2018 Odisha village level workers. Earlier rule ta.
Yeah. They said 2013 rules.
No, this is 2008 rules.
Again?
This is 2008 rules. It starts from page number 19.
Sir, page 16 ମୁଁ କହୁଥିଲି ଆପଣ.
16 ଟା ତ ବୋଲା.
16 ପରେ ଆପଣ page 50 କି ଆସନ୍ତୁ. Internal page 28.
नहीं इसी अच्छा page 20.
28. Internal page 28. Page 50.
28. All right. This is a letter.
Yes. There they have said. Your lordship kindly see.
See promotion कह दीजिए मुझे कौन promotion नहीं है.
ମୁଁ sir promotion. Your lordship interpretation.
Your first point is taken. The second point that second proviso applies, I don't think so, because this is because the rules. I recently have passed a judgment that I remember it, otherwise not.
My duty is to.
No. I'll tell you, Mr. Bhatt, please listen. See, this 70% and 30%. This 30% part again has two aspects. One is absorption of the existing GRS as data entry operators or accountant cum data entry operators, followed by selection. So this cannot be treated as a promotion.
My lord is well aware about Odisha Civil Service criteria for promotion rules. There, rule 3 specifically says, notwithstanding anything contained in any recruitment rule, the mode of promotion is by way of selection. That is what, my lord, I am saying. Because they have used that word selection over there, it will be, it needs to be, but subject to your lordship's acceptance. It needs to be.
In a case of promotion, there has to be a feeder cadre and there has to be a higher post.
My lord.
So if it is by way of a channel of promotion, testing the suitability, then what you are saying is correct. But here there is something else. The existing persons, subject to their service conditions and relaxation of age, they will be absorbed as a one-time measure. Thereafter, they will be selected.
My lord, one more thing, my lord, subject to your lordship's acceptance. Your lordship may reject my contention as wide enough, but I will take your lordships to this gazette issued by the government. I am giving a copy to him also. He is aware, but still I am giving a copy to him. Just a minute. But this is the document whereby state has classified the post under the state. Here your lordship kindly marked in the advertisement, it is a consolidated remuneration of 7,000. And in order to qualify a post to be included in any of the state civil service or post, this has to come through these classifications. And there is a pay scale attached to it. So here in the present case, the post in question against which we are concerned is not under the state civil post. So in order to bring applicability of ORV Act per se, itself is a misnomer. That is what my point, subject to your lordship's argument. I have given them the copy.
Yes. So we'll take it up next.
March 2016, my case for promotion was considered, and that is the document that Lords produced to Lordship. Therefore, Lords, the grievance of the petitioner to get promotion, Lords, the advertisement was issued pursuant to decision taken by the state government chief secretary, under whose chairmanship a decision was taken. They put the post to advertisement. At that stage, I came to Lordship. Lords, the university guided by Lords University Statute and University Non-Teaching Employees Promotion Rule 1991. Rule 91 specifically state that class 1 post shall be filled up by promotion. Admittedly, I was holding the post of programmer, and the next post is system manager. Well, they denied the same, saying in their counter that the post of system manager is a base level post. Therefore, it does not have any hierarchy to get promotion to the post of system manager. Lords, I have demonstrated with the documents that university statute as well as the university rules that the post requires to be because the rule says that the post has to be filled up through promotion. You cannot go for advertisement. That was my contention. Lords, they filed counter taking a 2 points they raised that because my case the DPC could not be held. Therefore, because of the financial, the order, ban order by the finance department. And further said that if I am entitled to get benefit, then I am entitled to get the financial benefit. They have admitted also in their counter. And since they insist upon this fact that the post is a base level post, and I do not have any right to get promotion, that was the condition. But that was under challenge. And the last occasion, Lord say kindly his additional affidavit.
Yes.
In additional affidavit, pay annexer B by 2, which I had also brought to your lordship's notice under annexer 11 by C. That your lordship kindly find page 15, internal page 15, system manager computational through promotion. There additional second additional affidavit.
Yes, yes.
Yes, page 15.
Through promotion.
Through promotion. So this is my case. I was kept in charge since 2004, allowed to continue as such without any financial benefit till my retirement 30th April 2021. And they continuously did not consider my case, and ultimately they came forward with this clarification. The language they have used in their affidavit, Lordship kindly see. Page internal page 2, para 4. That concerning the contention about filling of the post through promotion, it is humbly submitted that the post of system manager was a base level post till the university received clarification from the higher education department dated 30th March 2016. So they say, we got the clarification from the higher education department on this day, therefore I am entitled to get the promotion. My claim is that I am entitled to get promotion since I was kept in charge of the post. And Lords, the documents I have enclosed, Lords, we kindly see their own document also. They say the state government said under the chairmanship of the chief secretary, you need not ask the higher education department to fill up the post. And your lordship, again I am reiterating my submission that rule 91 say that the post is to be filled up by the 91 rule. Lords, in one occasion, this situation arose, and Lords, Mr. Ajidi then was Mr. R.K. Mahapatra, the senior advocate. He was called for Lords, one opinion that he had also specifically stated that the posts which are filled up before 91 came into power, that has to be filled up according to old rule, and after that, the authority can go for other rules. By taking aid of this opinion, they gave promotion different persons. My humble submission for lordship is that university statute and the rule govern the field. The higher education department has nothing to do with the giving promotion to non-teaching employees of the university. Lordship, kindly see the rule also. Non-teaching 13.2. Rule 13.2.
Yes.
Heading is chapter 3, and matter is relating to promotion. then posts are clarified. Then 2. The following post of officer shall be filled up by way of promotion. Deputy Register and its equivalent post, class 1 post to be to the extent of 1/3 of such post vacancies. So the post being the system manager post has to be filled up by way of promotion. Because they also admit their counter and the next below person continuing in the university is a program. So the necessary inference is to be drawn that I am being the programmer and next below the post of the system manager, I am to get the post of promotion. And instead of doing that, they went for direct recruitment that was under challenge.
Any interim order?
No, interim order was there. Lordship, kindly see page order number 2 dated 8/6/2009.
Shall be subject to result of the.
Yeah.
Now, what action have they taken in the meantime?
No, they have not given any promotion. I got retired as such without any.
Yes, Mr. Mahapatra, very limited point.
Yes,
You obtained a clarification from the higher education department that it is to be filled up by way of promotion.
with due humility, let me place it in 4 points only. Nothing more to argue in this matter. Admittedly, my lords, this post earlier government created this post to be filled up through direct recruitment. By the time the writ petition was filed, the condition of so far the direct recruitment, it was prevailing. But to that kind of a class, I think it will suffice. It might also go through my additional affidavit. As additional affidavit, page 10.
Parakun.
Page 10, page 10 no annexure.
Annexure number of
Annexure starts from page 8.
A by 2.
Annexure A by 2.
Yes.
Well, sir, this is the proceeding violation in the presence of the Chief Secretary, Additional Chief Secretary. That is Chief Secretary, page 8. This is the proceeding and resolution concerning filling of the post. There may kindly have a glance to page 10. Clause number 5.
Yes.
Non-teaching post. System manager computer. To be filled out through direct recruitment. So, my humble contention, by the time 2008, the post to be filled up through direct recruitment. That was the provision. He was continuing as a programmer, so continued in charge, but that is a different concept altogether. But the post is to be filled up through direct recruitment. That was the contingency by the time the writ petition filed.
Now, can this decision be taken to override the rules?
The rule has not specified all these things. I will come to that later on. Rule what my learned friend submits, it is equivalent to a particular cadre, and that is what he is entitled to get promotion. But the rule doesn't say that this post would be filled up through promotion.
The rule doesn't say anything at all. Rule says like this. I'm just posing a question to you. It will be easier for you to answer. The following posts of officers shall be filled up by way of promotion.
Right.
Deputy Registrar.
Yes, perhaps.
We are not concerned.
No.
And its equivalent class 1 post.
Class 1.
So we'll have to find out the pay scale.
Equivalent, then there is a declaration to that effect. Government time to time declare or university recommends declaration. There is no such declaration in this case because this is a resolution.
In sense of declaration, we can find out from the pay scale.
Pay scale comparison is so far this is concerned. I think it of no assistance because it is a technical one and these are all otherwise they are all entitled to. But fact remains, my humble contention is this.
Yes.
This is what this university has already taken in the earlier counter affidavit. Because it is to be filled up through direct recruitment, post is to be created by the government. Government specified the criteria, and we are bound by that criteria. Once government created the post, government specified a criteria, even in the resolution of to fill up vacant post. But the Chief Secretary has taken a meeting, and the Chief Secretary also decided in presence of others. Chief Secretary decided that yes, the post would be filled up through direct recruitment. So, my lords, this is a condition.
This cannot override any rule or.
Rule, my lords, has not specified so far that particular post is concerned.
So, what was the occasion to seek clarification from the finance department?
Finance department. Well, the thing is that post required to be filled up through direct recruitment. I think my lords, the finance department, I don't understand. Finance department code.
Sorry, higher education. I'm sorry, higher education department.
Higher education department, because they are the problem. They are the.
Why, what was the occasion? If it was already
They have
decided,
created the post, na?
it was already decided by the in the meeting presided over by the chief secretary.
Yes. No. Probably.
That it will be by way of direct recruitment. Then come to paragraph 4 of your additional affidavit.
Yes. Yes, my lords. Just level post. May I submit one thing?
The paragraph 4 that
concerning the contention about filling of the post through promotion, it is humbly submitted that the post of system manager was a base level post till the university received clarification from higher education department dated 33/2016, requiring to fill up the post through promotion. Till the said clarification received, the post was considered as a base level post to be filled out through direct recruitment. My humble contention of kind visual, I think it will be settled out in these way manners. My humble contention is like this. All the posts created under the university, this can be classified in three parts. One, post created on sanction of the government. Sometimes schemes are there. Scheme posts are created. These are usually filled up by the university. And in view of the direction of the Hon'Ble High Court to frame a scheme and all these things, some of the persons, those who were continuing for a pretty long time, they were also considered regularized and paid from the fund of the government university. The university now didn't have any fund. These are the three sources. These posts, on request of the university, was created by the higher education government in higher education department. So higher education, it is a regular post. The higher education department specified it should be filled up through that way because of the program and this post. These are two different posts and work activities are also completely different. So right or wrong, that post, there was a contingency, that there was a circular, there was an instruction that this post to be filled up by direct recruitment. And this position was continuing age on 2008. Then contingency arose, number of vacancies found in the university. So Chief Secretary took a meeting to fill up those posts. There two modalities were decided, not that to take note of a rule or all these things. These modalities, that is what I have enclosed in Annex A/2. This is the resolution speaks like reads like this manners. Annex B A/2. That was also communicated by the Director of Higher Education. They decided which of the posts to be filled up, the modalities to be filled up. Modalities they adopted to as per the previous instruction, information conditions while posts were created. So there they have decided they should be filled up through direct recruitment. Now question is, direct recruitment couldn't be held, that's a fact. Now question is that thereafter subsequently in letter dated 33/2016, that is Annex B/2.
I want to know what is the occasion? What was the occasion for the higher education department to step in?
The higher education department created that post.
But why in 2016, if a decision was taken, policy decision, whatever, yes, it was taken that it has to be filled up by way of open recruitment. Then why suddenly
higher education department has taken a decision, and I think the basis of taking such a decision is not within my knowledge.
No. I just wanted to ask you whether there was any occasion, whether there was any communication made by the university.
There was no communication at all.
You have to inform, because that therein lies the key.
I understood that, but therein lies the ascertain. There is no communication, and that no such reference also there in the letter. Annex kindly be class to Annex B/2.
Mr. Mahapatra, I am not going to undertake the journey that you are trying to
minors require
take me to. I am
this is what is called judicial mind minors. I don't want to touch in there because I am conscious of the position.
And this court is very, very conscious of your competence as a lawyer. There is absolutely no.
With border minors in that respect, I am not. Minors wanted to know.
No, I want to know what prompted the higher education department to come up with this. It does not refer to any letter number.
No, doesn't refer to any.
Subject creation of abolition of post. The posts were already there. Directed to, and the decision was taken to fill up through open recruitment. That part of certainly in 2000.
That's what is not within my knowledge. Please take it. I will take instruction.
Please take it.
I will take it.
No, document he has not gone through. Here also kindly see page 70 and 71. What is
page? Page is something not.
Sir, Annex 12.
Annex 12?
Of the
gender.
What was created by UGC? Perhaps my learned friend has not gone through
UGC does not create any post.
Yes,
UGC squad the post.
Please, bro, kindly wait. Kindly wait.
UGC cannot create a post.
Next page. University Grants Commission. The heading is University Grants Commission. Letter to the Registrar Utkal University. Establishment of Computer Center at Utkal University. That is the language. And post created is as follows. Page 71. Annexure 12 by 8.
So I will ask Mr. Mapatra to go through all this, and we can continue next week as this as.
Vice Chancellor, no need to take advice from the Higher Education Department. Kindly see page 9.
The Higher Education Department is helping you
That's true, but because the documents are available with me, that is also.
Let Mr. Mapatra go through it. Let him go through. Let him go through. We'll continue next week, but please,
I will take the instruction.
please assist the court on this.
I will take that instruction, madam.
Because you see, this looks a little bit incongruous.
I understood, madam. Unless university requests, why they shall reconsider this prospect and say that you should build up the promotion.
No, nothing was. Decision was already taken in a high-level meeting headed by the chief secretary. No less. The chief secretary, the highest.
Yes, madam.
Sir, I would have page 95 देखिए page 95.
देखिए नहीं.
Said I say chief secretary. And that is the 5/4/2007 sir. 2 देखो specifically कहते University need not ask for permission of the government for filling of the consequential vacancies in teaching and non-teaching posts arising out of death, retirement, promotion, resignation, etc. Only minimum student strength has to be ensured.
No, I have already asked Mr. Mahapatra to find out this is one part. You will answer next.
My lords directed specifically to know under what circumstances you reconsider it, and you said it that it should be filled up through promotion. Whether university requested or not, if that is so, then what is the contingency? That is what I am to approach. What my learned friends refers to, this is a different thing. University is to fill it up, not that other authorities will to fill it up. Now the law is that other agencies have been formulated and OPSC and other kinds of things. Then this university was the authority to fill it up. There is no bar in that.
But I will ask also, Mr. Mahathi, you have already retired. Now promotion has to be through a DPC.
Minors, that is the.
It cannot be granted on its own. One thing can be considered, as you have said, that you should have been considered at the right at that moment of time, and according to you, arbitrarily you are not considered. So, what will be the ultimate result of this retirement?
No, I have come up with
only one line.
Latest documents. 2 documents have come up. Plus, even if they have not held the DPC or convened the DPC, they have extended benefit to retired persons. So that document I have enclosed.
That will
even after they retire.
Then give that to Mr.
Then I have supplied.
And Mr.
In my objection to his second counter affidavit, I supplied the same. Specifically.
We'll continue next week, Mr. Mahapatra.
Here in this case, RSCP, MSCP, because of the stagnation, that all the benefits have been extended.
No, financially he may not be get.
Say admit person na, say paibe he is entitled to get.
No, even if he gets, supposing.
I would read file kare, I would read file kar se patre. ଆପଣ ଯୋଉଟା ମିସକେସ୍ ରେ ଆମେଣ୍ଡମେଣ୍ଟ କରିବାକୁ ଚାହୁଁଥିଲି ମିସକେସ୍ ଟା ଆପଣ କହିଲେ ନାଇଁ ସେଇଟା ପାଇଁ ଆଉ can come
up relating to RSCP and MSCP paid in a lesser scale. If it would be decided, then you will be entitled to a higher grade pay. There is no problem in that. That will depend.
But if supposing this prayer is in this rate application is allowed, then that becomes infructuous.
That will become infructuous.
That becomes infructuous.
That will become infructuous.
So you find out what order can be passed here.
Lord, they can.
Supposing everything the court accepts whatever you say.
My lords.
What order can be?
The lords, they can convene a DPC, post DPC, and decide my case.
Retirement
for a retired person.
Lord, that's true because in the case, lords, if that is so, lords, they have extended the benefit even.
Yes. So at best, you may claim for that promotional scale of pay retrospectively, or for fixation of your salary, last salary in the selection in that post, so that. Your
promotional benefits or retirement benefits may be modified.
That the only thing that can be done, because a retired employee, you cannot ask the authorities to hold a to convene a DPC for a retired person. No. Anyway, just find out. Third and part, let's this matter next week. देखिए 30th July, Mr. Mahapatra? 30th July, yes.
I don't know, 9.
So Mahapatra will take instruction.
Yes. My lord,
Yeah, already you remind me.
was my lord said is enough.
9 not pressed, dismissed as not pressed.
I don't know, 10.
Yes, you are saying something? Yes?
I want to say that we are not placing the
Yes.
place.
Do you file any memo?
Yes.
I don't know, 10.
I please your lordship, I am appearing on behalf of G.R. Tripathi. Lordship, no instruction may be disposed of.
No instruction disposed of.
I don't know, 11.
Your Lordship, I am appearing on behalf of Senior Counsel Pradipta Mahanti. We are appearing for OPPI, Your Lordship.
Who's for the petitioner? To dispose of? Good pass over कर दी था.
Your Lordship, this matter has become infectious.
हाँ जी, सी कौन सी था तो चलो असली में dispose of कर दो आप. Item 12.
Item 12.
Yes, pass over. गोटे पास ओवर कर दिया लॉन्च पर देखिए नॉलेज डिस्पोज ऑफ कर दो आप
लॉन्च होते हैं
Item number 13.
13 minute registrar is ready, but I have not filed it in the registry, my lord.
Okay. You file it here? See, General and Counsel appearing for the petitioner files rejoinder in the court. Have you served copy?
Just now.
After serving copy on the State Council, same be kept on record. Let's this matter next week. Huh? Next week, yes.
1 week after.
Acha, who 1 week after?
Can I take the instruction?
6th August.
Yes, most of it.
Item 14.
Item 14.
The pass over.
Item number 15.
Because of my personal way, I am the fisherman.
Yes.
I am for the appointment.
Madam, the matter is regarding the.
This is for final disposal.
Yes.
Samadhi.
Madam,
आपण अपेयर करो तो फिजिकली फाइनल डिस्पोजल वर्चुअली मुझे कर दीजिए I'll call it tomorrow.
And that, my lord, I have prepared a small affidavit. I said, sorry, Mr. Mahanti, I'll let it come next week, my lord.
अच्छा, he is filing an affidavit, so he'll serve a copy on you. It will come next week.
next week, you may also may fix up a date.
Date. Learned counsel for the opposite party files an affidavit. Opposite party number 5 files an affidavit in court. Let a copy of the affidavit be served upon Sri Mahanti, learned counsel for the petitioner. Let's this matter next week. Next week, man, 30th. 30th tarikh.
Item
Yes.
16.
My lord, I am for the opinion number 7. In double BC 25094. The counter is ready, just 1 week time for
What is it?
Lordship, kindly see one point. We have been
Last chance,
selected
last
since
chance.
long.
This is the case.
Just a minute. All right. We have been selected. Appointment letter was issued to both the 2 writ applications were there. Date was fixed. Whenever we went to join, but we are restrained to join. Thereafter, my lord, I filed a writ application before this one, 2 writ applications for 2 persons. Direction was given for consideration of this year. And they rejected it on the ground that the villagers are opposing. Only that is the ground. And behind our back, a person who has not taken part in the selection process, he has filed one appeal
Challenging the advertisement.
challenging to quash the advertisement. Only my sole ground is, my lord, number 1 is
For the ADM.
for the ADM, right?
And that was allowed.
We have not been made a party in the admitted in this head appeal. Number 2 is by virtue of that that is procedure that is laid down as a revised guideline. The power is not vested to the ADM to deal with the advertisement. Only in the selection process. Only 2 points. The legal point is Admittedly, we have not.
So
been-
this has to be heard.
Exactly.
This has to be heard. This is a point of law.
Only point of.
Point of law.
We want to show.
Point of law is further ADN has jurisdiction to hear the appeal.
Only it is a.
He wants to file a counter. I will grant him only one chance.
Yes, sir.
Last chance.
Learned counsel for the opposite party number 7 seeks some time
2 weeks time.
to, no, 2 weeks देंगे.
ସେ ଆସିବ କନ୍ଧମାଳରୁ ସେ
ଯୋଉଠୁ
ଯୋଉଟା
ଆସୁ.
ଗୋଟା
ସେ ଯୋଉଠୁ ଆସୁ.
It is ready.
କନ୍ଧମାଳରୁ 4 ଘଣ୍ଟା ଲାଗେ.
ତା ଭିତରେ ତାକୁ ଫୋନ
କନ୍ଧମାଳରୁ 4 ଘଣ୍ଟା.
ଆଜ୍ଞା ଆଜ୍ଞା ଆଜ୍ଞା
4 ଘଣ୍ଟା एकदम ब्यूटीफुल रोड. I have recently come 4 ଘଣ୍ଟା 15 ମିନିଟ୍ ମତେ ଲାଗିଲା. ତେଣୁ ଆପଣ 2 ସପ୍ତାହ
2ରେ ରହୁ
ହଁ ସେଟା ହେଇପାରିବ. Learned counsel for the opposite party number 7 wants to file a counter and requests for some time for the purpose. List this matter on CORAM.
ଅଗଷ୍ଟ 2
6th August.
public
Interim order is there.
Interim order to continue.
Diplo.
Parties are requested to come ready for final disposal.
if my lord regender that is to file
No, why result?
Point of law, your lordship. It is completely point of.
Yes. Item 17.
Item now 17, 18 and 19. The cases are identical. On the last occasion also, my lord, I had some time to file the counter, my lord, in this case. It's a second round litigation where the rejection order is there. So, my lord, 2 weeks time may be granted.
Yes, Mr. Satpathy.
My lord,
He wants some time, 2023 matter, all right?
lordship, fixes.
But no further time.
No further, last answer, lordship.
Sri S.N. Patnaik Leonard AG requests for further time to file counter, which is opposed by Sri Satpathy, Leonard counsel for the petitioner. List this matter on
17 September.
no, August.
27th.
August. It is made clear that no further time shall be granted for filing counter. 17, 18, 19.
My lord,
Item 20.
I don't confirm, my lord.
Yes.
The government already filed a counter affidavit, my lord. No, I have to file a rejoinder, my lord. So sometime.
Sri Satpathy, Leonard counsel for the petitioner wants to file rejoinder to the counter filed by the state and requests for time. Stop. List this matter on
20th August.
20th August. Rejoinder, if any, be filed in the meantime.
Item 21.
Okay, nothing. All right, pass over. We'll call out again before rising. We'll call out.
Item 22.
22. Good, outside.
Item 23.
24.
Item 24.
Your lordship, on behalf of Mr. Ukipanda, your lordship.
Yes.
Your lordship, on transfer of petition of.
Let us first see whether somebody is appearing for the opposite party. Yes.
Your lordship, transfer petition from family judge Kujang to family court Kendrapada, your lordship.
Kendrapada, why?
Your lordship, my marriage was solemnized on dated 4/7/2020.
That is no ground for transfer.
Your lordship, ground was that the present court is so far away from my home, your lordship, and the second point is
where are you residing?
I'm residing in my maternal house in at Kendrapada, your lordship. And second point is that, your lordship, I'm fully dependent of my parents.
The petitioner wife has filed this application seeking transfer of CP number 94 of 2016 pending in the Court of Learned Civil Judge Senior Division Kujanga
Yes.
to the Court of Learned Judge Family Court Kendrapada. Therefore transfer has been made on the ground that the petitioner is residing at Kendrapada and lacks financial support for which it would be inconvenient on her part to. What is the stage of trial? What is the stage of the case? 2017 matter. Yes.
Lordship, I have no instruction, your lordship.
Hello. Okay. We'll call this next week. In the meantime, you obtain instruction with regard to the status of the case. Learned counsel for the petitioner shall inform the, is directed to obtain instructions as regards. File 22.
On behalf of my grand lordship, this matter is transfer of application which is pending before the burger, that is, my lord, Sonpur Court, in the restoration of conjugal, section 9 of restoration of conjugal acts. So it is the different.
Notice is not sufficient. That is a problem in this case. And what is the precedent?
Notice has gone to the opposite party.
It is not sufficient.
Yes, my lord.
Neither ready nor undelivered notice returned. Yet from solvent tracking report also not generated. You'll have to take notice again.
Fresh
And
notice.
what is the stage of trial?
That is, my lord, that is stop. No proceeding is.
All right.
That is the interim order, I think. My friend was.
No, interim order से 2018 नहीं था, तापरे Asian resurfacing पर गुड़ा case को ये कर दिया इतना ना.
Again.
So
I have no instruction. I will take instruction, my lord, regarding the status of the case. And this case is belongs to my friend. I have no knowledge about.
learned counsel for the petitioner is directed to take instructions with regard to the present status of the case in the court below. Please this matter, Kevin.
13th August.
13th August.
So entry order earlier.
Interim order to continue.
Earlier that may continue.
Item 23.
23 ଟା ସେଟାର status ଟା କଣ
Plus the
ଅଛି?
first notice. Yes,
Ask you status ଟା. ଯଦି ସେପଟେ dispose of ହେଇଯାଇଥିବ.
ତାର status ଟା କଣ?
Yes, same order.
Same order ହଉ next week ରେ ଆସୁ.
Is there any interim order?
Interim order ଥିଲା.
Interim order to continue. Next week same order କରିଦବ. Yes.
Item 25.
Item 25, my lord, your lordship was placed to at the verge of my lord passing order in the previous date, allowing the transfer application. I made a submission, my lord, that the petitioner belonged to under the jurisdiction of Bodamba, Civil Judge Senior Division. And so therefore, I wanted to file one amendment application. I took instruction that that power to deal with the matter case is not vested to Bodamba Civil Judge Senior Division. No. So it is Athagad.
It is?
It is now before Athagad, the civil justice.
So you wanted to
transfer the case, my lord.
But what about the status of the case?
Well, I do not have any.
So that you have to say.
The stay is granted by.
No, the stay was there in 2019.
It is absolute correct in my case also.
So in the other case?
Other case.
You have your case only.
My lord.
So you take instruction better.
It is absolutely.
যদি নথিব we will pass that on.
Mapatra
learned counsel for the petitioner is directed to take instructions with regard to the present status of the case in the court below. List this matter.
6th August. Sir.
Huh?
6th August.
6th August, interim order to continue.
Item 26.
You know that Rathore there, I think. My father and son being awake for the entire night, you know.
My lord, item 26, I am for the petitioner, my lordship.
Item 26 कौन है जी?
I'm for the petitioner, my lord.
I don't know the order should be corrected appropriate. Yes, you are the
petitioner, my lord.
Yes. What do you want?
My lord.
कौन था ये?
My lord, as per the noting, my lord, in order number 2.
Sera correction. correction
On the last occasion, my lordship, my lord has directed us to file the consolidated PRP petition, my lord.
You filed?
Yes, my lordship.
Yes. Then?
And the matter was actually.
So notice has to go.
Notice is already issued, my lordship.
Notice has
in the earlier transfer petition, my lordship.
What earlier transfer?
First, we have filed one transfer petition. And subsequently, we have filed another consolidation petition, my lordship.
So this has to, notice has to go.
Yes, ma'am.
We submitted that consolidated application has been filed. Such being the case, issue notice to the sole opposite party by speed post, fixing a short returnable date. The requisites be filed by tomorrow. Peremptorily list this matter on
3rd September.
3rd September.
Item 27.
Pass over, my lord.
All right, pass over.
Pass over.
Pass over down. Item 28.
Item 28.
May I please? Allowed here the petitioner is the wife seeking for a direction to transfer the MAT case pending before learned
Learned Senior Civil Judge Rajgangpur in MAT case number 19 of 2023 to the file of Learned Judge Family Court Kendrapada, Your Lordship.
Yes, you're the wife.
Yes.
On what ground do you want transfer?
There are two grounds, Lordship. Number one is the distance. It is around 400 kilometers from Kendrapada to
Rajgangpur, yes.
And number two is that one litigation is already pending under section 125 of CRPC. I have also reflected in para 5 of my petition.
What do you say?
Yes, my lord, there is a pending of a case in the family court, Learned Family Court, my lord. But the opposite party is earning 8 to 10,000 a month, my lord. In every date, he is to visit, and my lord, it is not possible from the opposite party to visit the court, my lord.
I'll grant you, that liberty to oppose the court for virtual appearing. Appearing through virtual mode. The petitioner wife seeks.
My lord, a small prayer, my lord. A direction may be given to the Learned Family Court to conclude the trial within few days.
The petitioner wife seeks transfer of MAT case number 19 of 2023 pending in the Court of Learned Senior Civil Judge Rajgangpur to the Court of Learned Judge Family Court Kendrapada. Transfer is sought on the ground that the petitioner is residing at Kendrapada, which is at a distance of more than 400 kilometers.
370 around.
It was I have written 300, but
which is
approximately it will be.
Which is at a distance of nearly 300 kilometers, 400 kilometers from Kendrapada. Moreover, another proceeding being case number, another proceeding under section 125 of CRPC is also pending before the family court at Kendrapada. Stop. Learned counsel appearing for the opposite party husband opposes the prayer for transfer by submitting that the opposite party is a low income earning person for which it would be difficult on his part to travel from Rajgangpur to Kendrapada to attend the court on the dates of posting of the case. Para. After considering the relative inconvenience that may be caused to the parties, this court is of the view that it would be more inconvenient to the wife if the proceeding continues at Rajgangpur. Under such circumstances, this court is inclined to allow the prayer for transfer. It is directed at such and such. It shall be open to the opposite party husband to seek seek permission of the court to appear through virtual mode. Each step shall not be necessary. Unless absolutely necessary, you will not insist upon your personal. Yes.
My lord, prayer for conclude the.
Yes. Further, Quebec case.
Recently filed.
The family courts are loaded with cases, so it will be very difficult. Yes.
At least within a year, my lord.
No. Yes.
Can I be excused? 27, I just was entering.
Yes. Item 27.
Well, there are two transfer petitions, one by me and one by the wife. In my transfer petition, I am seeking transfer of the 125 proceeding which has been filed at Sambalpur to Kendrapada. The divorce application which has been filed by me, they seek a transfer to Sambalpur. My lord, my humble submission before your lordship is that if a mediation is done, I think parties can settle the matter.
It's a good suggestion.
That is
In case of mediation and you all
the assistant professor is also both are
affluent and educated and all that. If they want to separate, let them separate.
Only both of them want to separate because
they are
because what I gathered information from my client that the wife is also ready for separation, but question is regarding the quantum of permanent element. So that the mediator can fix it better, because seeing the salary and all factors, it can be decided in a much better way.
It is in course of hearing, it is stated at the bar that the nature of the dispute is such as can be attempted to be resolved amicably through the process of mediation. In such view of the matter, let the records be placed before the coordinator of High Court Mediation Center, so and so, so and so. Place this matter on 17th September.
The interim orders in both may be.
Yes, interim orders to continue.
Both the cases may be there, so that in the meantime.
Both dita cases they cut order now.
No, no, more separate करते हैं, more adjournment petition पे इंदे.
No, dita cases similar order.
Item 29.
The petitioner being the wife seek for transfer of CP pending before the Law and Family Judge Cuttack to Law and Family Judge Kendrapada. The grounds she has no independent source of income. On the other hand, seeing along with his son staying at Kendrapada, son is studying at Kendrapada by Annex 3, identical source my. In this case, notice has gone, but not.
I am appearing for the opposite party number 2, my lord.
Is it father-in-law? That's
who is
number one?
OP number 2.
OP number 1 पे अपना appeal करना.
Number 1 not yet appeared.
Service of notice completed on OP number 1. So it is sufficient.
Yes, madam.
So we can dispose of.
Yes.
Since you are there, we can dispose of.
Yes, ma'am.
What do you say?
My lord, myself.
Allegation
Myself is the father-in-law, my lord. Father-in-law of the petitioner.
What about the husband?
OP number 1 alleges that she has illicit relationship with her father-in-law. The petitioner has illicit relationship with her
You was already tortured to the daughter-in-law. So I ଯେତେବେଳେ ମୁଁ ତାକୁ ବ୍ରେକ୍ କରେ ସେ ମୋ ଉପରେ ଆଷ୍ଟୋନିଶ ହେଇକି ସେ ମୋ ଏଗେନ୍ଷ୍ଟରେ କେସ୍ କରିଛି ଆଜ୍ଞା. If the case will transfer to the if the case will be transferred to Cuttack to Kendrapada, I have no objection.
All right. All right. The petitioner seeks transfer of CP number 650 of 2023 filed by her husband in the family court Cuttack to the family court Kendrapada. Opposite party number 1 is the mother-in-law, and opposite party
number 2 father-in-law.
One key.
One is the
husband.
Opposite party number 1 is the husband, and opposite party number 2 is the father-in-law of the petitioner. Notice on opposite party number 1 is sufficient, but there is no appearance from his side. Stop. Prayer for transfer has been made on the ground that the petitioner is residing at Kendrapada along with her minor child, who is pursuing his studies there. As such, it would be inconvenient on her part to travel to Cuttack to attend the court on the dates of posting of the case. Learned counsel appearing for the opposite party number 2 submits that his client has no objection if the case is transferred from Cuttack to Kendrapada. Under such circumstances, the transfer application is allowed. So and so.
Okay.
Item number 30.
Wait, let's see. Present petitioner is the wife filed the transfer petition for transfer of the MAT case number 108 of 2022 from the Judge Family Court at.
Unclaimed.
Let's see. Address was correct given. Let's see. Not received.
Take notice through the state police. Yes. Unclaimed. Unclaimed. But nobody claimed that notice. If this thing happen, you make an effort through the local police.
Local police station.
Let a copy of the transfer application be served upon the State Council by tomorrow. By tomorrow, who shall cause the same to be served upon the opposite party through the IIC of Kothana. देखले? IIC of Tigiria Police Station, indicating that the matter shall be taken up for hearing on
20th August.
20th August. Hon'Ble. Let's this matter on 20th August.
Item 31.
31.
I am an BC, my lord.
Yes.
The two cases has been filed, my lord. Transfer of the proceeding from the Judge Family Court Cuttack to Judge Family Court Dhenkanal, my lord. One CPG filed section 6 of the Guardianship Act.
Who is appearing?
The
Let me see. Let us see whether
appeared. Both cases he had appeared, my lord.
yes, somebody is appearing. Mr. Bipin Kumar Naik is appearing.
Like it appeared, yes.
We will grant him one more opportunity. Then counsel
Yes,
the petitioner is present. None appears for the opposite party on repeated calls. Let's this matter next week. Interim order to continue.
Item 32.
Yesterday also the OP was absent, for that reason you also kept it for 2.
We will dispose of.
This is I have 5.
Order to the
32. Counter, they have filed counter.
Then counsel of the petitioner is present. None appears for the opposite party on repeated calls. Yesterday also there was no appearance from the side of the opposite party, for which the matter was adjourned to today to grant an opportunity to the opposite party to appear. So, since there is no appearance, the matter is taken up for hearing. Yes.
Should I file this suit for transfer? This application for transfer the suit from Cuttack to Kendrapada.
Yes.
Lordship, fine, Lord. The petitioner, the opener one is the plaintiff. He himself is the resident of address given, that is the resident of permanent resident as well as present resident of the Kendrapada.
This is a civil suit. I think he has also filed a counter.
He have also he has filed.
So I'll give him one more opportunity. This is a
that is not, it can be filed. There is
This
no
suit for partition.
please put the date.
Is this a suit for partition?
To partition as well as declaration.
Yes.
Admitted, I am the OP number 1. Mr. Samal is ill, so I'll get next week. 1 week time.
OP number 1. Notice was issued only to opposite party number.
That is all the proper only.
Therefore, adjournment is made on behalf of Learned Counsel for the opposite party number 1 on the ground of his illness. Is this matter next week?
Next. Interim order.
Interim order to continue.
Item 33.
33, my lord. As per the noting, my lord, the notice has written on delivered that with the noting that address is not located.
What is the meaning of it? Address is not located. You have to copy them through the police service. Police service. Let a copy of the transfer application be served upon the State Council, who shall cause the same to be served upon the opposite party through the IOC of Mondamunda Police Station. Indicating that the matter shall be taken up for hearing on
20th August.
20th August. List this matter on 20th August.
34.
I am appearing for appeal party husband, kindly.
Lord, wife's petition for transfer of the met case number 47 of 2024 to the Court of Learned Civil Judge Khariat.
PK Prasad enters appearance for the opposite party husband by filing Wakalatnama in court. Same be kept on record.
Lord, my Lalant Fed also has no objection. If it is transferred to the Lalant Family Court Bolangir, only he wants to join by virtual mode.
All right. The petitioner wife seeks transfer of MAT case number 47 of 2024 pending in the court of learned senior civil judge Khodiar to the court of learned judge family court Balangir. Therefore, transfer has been made on the ground that the petitioner is a resident of Patnagarh, which is nearer to Balangir, but more than 100 kilometers away from her home. But that's how it is.
From Khariar.
From Khariar. Learned counsel appearing for the opposite party submits on instructions that he has no objections to the objection to the prayer for transfer. In such view of the matter, the transfer application is allowed. Last time you virtual mode.
Yes. Published.
Item 35. May I please, in this case, file for extension of date of surrender. On the ground of petitioner's son is 4 years old child and he is a heart patient man. Sir, operation I'll take care of him. What is
Considering the grounds, the interim bail granted by such and such is extended by a further period of 1 month.
2 weeks, more 2 weeks.
6 weeks.
Yes,
6 weeks.
Item 36.
I don't know.
In course of the Kali surrender data.
Oh, in course of the day. I see the question. Yes.
I don't know that it's kind of talking about
Tomorrow. Tomorrow?
No.
This matter tomorrow is paid for.
Item 37.
Shut
Item 38.
May I please? Your Lordship heard this matter several occasions. I have nothing to say before Lordship. He is inside the custody since 5/12/2021.
5/12?
2021.
कौन है चीज रे? आगु रिजेक्शन है चीज?
हाँ रिजेक्टेड थला. 326A. I am praying for interim. Yes, for that reason I have never opened my mouth. 3 years. In shorter period because
acid attack रे किछ हो. मैं आपको मना करछि.
मना करतले.
Acid attack there will be absolutely no leniency.
नहीं दी भाई को भीतर गंडगोल कहला वाला तक प्रॉपर डिस्प्यूट दैट इज
खलास है.
लाड़े
ये हां खलास है.
ये लच्छे में काई से लिखित जे मु that previous ये थिला.
Mr. Das, I'll make it easier for you. I'll reject it on merits. I'll reject it on merits. So no, once it was rejected.
It has been rejected. Your Lordship target and my.
No, there is no target.
Expeditiously, na.
Now we can target. The petitioner is in custody in connection with such and such case. It is submitted that despite being in custody for nearly no more than.
More than 2 years, 5/12/2021.
5/12/2000 for nearly 3 years. No, so for more than 2.5 years, trial has not concluded. Stop. This court finds that the petitioner's bail application was earlier rejected on merits, as per order passed in BLAPL number 6941 of 2023, taking into account the gravity of the offence and existence of materials prima facie in support thereof. I find no change in circumstances to warrant a different view being taken. Stop. As regards the delay in trial, the trial court can be directed to expedite the trial, but the same in the facts of the case cannot persuade this court to take a lenient view as regards liberty of the petitioner. Stop. In such view of the matter, the bail application stands rejected. The trial court is directed to expedite the trial and to conclude the same as early as possible, preferably within a period of 6 months.
Liberty. Only for satisfaction myself, Mike. Only liberty.
I also have to pass an order to my satisfaction. Yes.
I don't have to. May I please, my lord? My lord, earlier your lordship is protected interim protection of 3 weeks.
What includes the regular bail, brother?
Filing
Interim bail granted
3 weeks. I have surrendered before this jail, my lord. What happened, my lord? His son is now going to be appearing in the metric examination, my lord. That is a admit card is there, my lord.
Metric परीक्षा ये जुलाई में सर?
इतना अच्छी supplementary है इधर admit card सर हम मिचो परीक्षा में चलती सर
जी supplementary परीक्षा दूसरी और शेयर
कहीं नहीं तब वाइफ एक्सपायर ये 3टा छुआ बर्तमान तार प्रॉब्लम होची केमती रहिबो कोन करिवो सेटा होला तापरे या नारे 18टा विटनेस ऑलरेडी एग्जामिन या नारे किछि नाही किंतु आउ 21 रु 18 गलेडी आ ठीक रिलीज ऑन बेल मेन एक्यूज्ड कस्टडी अछि
ट्रायल सर्जरी तो ट्रायल सर्जरी तो ऑलमोस्ट सब
सलाम के ट्रायल पर्यंत रहू
ऑलरेडी आरंभ हो तो परीक्षा
से परीक्षा पर से आसीपान केस आ जेते लिस्ट मु दिथर मेमो देली
The petitioner was earlier granted interim bail for 3 weeks and he surrendered to custody in time. Presently, therefore,
once extended also.
Therefore, interim bail is made again on the ground of matriculation packet supplementary examination of his child. Sri Pradhan Learned Counsel for the petitioner files copy of the admit card of the petitioner's son, which shows that the examination is scheduled, is being conducted from 22nd July to 30th July. So, it is further submitted that there is no other person in the family as the petitioner's wife expired recently. Learned State Counsel opposes the prayer for bail by submitting that trial is in progress.
The fag.
Considering the submissions on the ground on which the prayer for interim bail is made, I am inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 10 days.
10 days.
Initially, sorry,
this is the admission. Admission पर्यंत टे दियो 2 मास दियो 2 मास
2 मास मु 10 दिन रहउछि 2 मास
दियो तो काहे कि ना
2 weeks no.
Disposed of,
disposed of.
Yes. Item number 40.
Is your lordship.
Yes.
Lordship, offence is under section 302 34 APC, subsequently turned to 302 120B IPC. In this case, I am moving application for Tinku alias Staman Kumar, my lord. In this case, on 15/5/2023, the accused is from that day the accused is in custody. In between that period, rest of the accused persons already enlarged on bail by the order of this court, my lord.
Does he compare with this Akash Patra?
Akash Patra, not similar, my lord. This Akash Patra only facilitated for assault, but this present petitioner was already present at the spot, but co-accused statement, and this is a remand case. After the occurrence, this case occurrence date is 24/23. After 2 days, he has been arrested in one Sambalpur PS case number where he was remanded to this case. but co-accused statement.
Co-accused
And this petitioner was present at the spot. And Akas Patra only facilitated for us.
The petitioner is in custody since
15/5/2023, sir.
15/5/2023 being remanded in connection with such and such case. So which is that?
Sambalpur.
On whose statement? On whose statement was he implicated? Ajit Sandha?
Ajit Sandha.
All right.
And two disclosure statement, one Vivek Sinduria and Pintu Bahadur.
All right. The prosecution case is that the deceased and his friend had gone to Jharsuguda to celebrate the birthday of their friend. Stop. While returning on a bike, some unknown persons stopped him on the way and severely assaulted him, causing bodily injuries, due to which he ultimately died. The petitioner's complicity came to light during investigation through the confessional statement of the co-accused Ajit Sandha. So, further, the petitioner's name also figured in the disclosure statements of two other co-accused persons.
Vivek Sinduria, Pintu Bahadur.
Madam. Save and accept these statements. There is no other independent material showing the involvement of the petitioner. In such view of the matter, I am inclined to allow the prayer. So and so. Yes.
Item 41.
And I for interim bail, my lord. The wife of the petitioner is ill, my lord, suffering from neurological problem. Lord. Initially, she was treated at Kotak, Balakrishna Gaur and other doctors, my lord.
Partly instruction has come.
He's asked for that, asked for some time.
Yes. Sabujanga document verify, but local inquiry has been made and
Both certificates are there.
She is ill, my lord.
I have also
local inquiry has been made.
All right. Learned State Council, as Director, Learned State Council has taken instructions from the IAC of Info City Police Station to the effect that on local inquiry, it was on local inquiry and physical verification in the village of the petitioner, it was ascertained that his wife, Nesatun Bibi, is undergoing treatment in consultation at DHH Jashpur. As such, there is truth in the, as such, the document, considering the above information received, this court is inclined to take a lenient view. Let the petitioner be released on interim bail for a period of 1 month. No.
2 months, my lord.
No. Yes.
Neurological problem.
No.
Custody since last 1 year.
Yes.
Item 42.
I don't know, 42, my lord, may one pass over.
All right, pass over.
Item 43.
Kitara pass over is?
Co-accused are on bail. 42 down.
The petition stands on safe footing.
Co-accused ki?
My lord, co-accused Debocharan Jaiji, ye Kartiyo Kishan. 8/2/21 custody, 128 kg, 300 grams of ganja. My lord has granted bail on 19/7/24.
Debocharan?
My lord.
He was the driver of the offending vehicle.
No. I'm on something else. This Debocharan was granted bail along with Karthik Kirsani.
Interim bail ଯାଇଥିଲା
The interim bail.
interim bail ତାପରେ interim bail ଯାଇଥିଲା
All right. We'll pass the same order. ରୁହନ୍ତୁ ଆଜ୍ଞା.
You are the
Yes.
driver and this person is sitting behind you.
Same order.
Item 44.
May I please, your lordship? This matter was heard by your lordship. I have filed this bill application for interim on health ground, your lordship.
I rejected.
Yes. No, it was withdrawn, my lord. It was
No, the co-accused Ajmer Ali I have rejected. He stands on the same footing.
Same put.
How no?
From तारो लक्षे टंका recovery इतला यार 46,50,000 has been recovered and some gold ornaments. Apart from that, 12 criminal antecedents of similar nature.
My lord, my son is suffering from illness, from brain infection.
No.
I have the medical documents, my lord.
No.
All total 1 crore 68 lakhs has been recovered from all the accused persons.
No. The petitioner is in custody in connection with such and such case. It is alleged that in between, either जो है नहीं, ये order कर दे. इतने जो connection है, ये order कर दे. No, rejected. Yes.
Item 45.
45 please, your lordship. In last order, lordship directed to granted liberty to renew my prayer after examination of two witnesses, namely Niranjan Naik and another one is Arjun Naik. In the meantime, two has been already examined and declared hostile. The present petition is custody since 15/11/2021. The present petition is the mother-in-law of the deceased.
Niranjan Naik and Arjun Naik.
Arjun Naik.
Correct.
That is page
Yeah, the
20
next
to 23. I have annexed under annex to 3 series.
As it seems,
Both of them have turned hostile.
Both turned hostile. Mother-in-law.
The earlier application of the petitioner was rejected, granting her liberty to renew her prayer after examination of two witnesses, namely Niranjan Naik and Arjun Nahako.
Yes.
In the meantime, both of these witnesses have been examined. From the copies of depositions of the said witnesses enclosed to the bail application, it is seen that both of them have turned hostile. So, under such circumstances, the case against the petitioner, under such circumstances, there is prima facie no cogent evidence showing complicity of the petitioner in the alleged occurrence. Under such circumstances, I am inclined to allow the prayer for bail, so also. Each day appearance.
Item 46.
May I please, lordship. My lordship is directed to medicine center. That is flag B, my lord, medicine report, my lord. The infant did not come, my lord. In 2 days, she was appear, my lord. In subsequent, she did not appear, my lord.
ये 8-5 को जाइଥିଲା ତାପରେ
Last order to my lord, 26/6 of 2024, my lord. Last order, my lord.
ये तो नहीं है
See,
27/3 ହେଲା
it is, my lord.
so se order ta ଅଛି जे what about the mediators
Medicine report, my lord. Final report.
final report
My lord.
all right good. Has it been successful?
No, my lord. Because of due to infant did not come, my lord.
The report
Neither
of the
is
mediator dated 26/6/2000, you file it. You file this copy.
My lord.
Filed by the petitioner shows that
That is also my lord flag.
the mediator that the
it appear करदल infant also appear in
see failure ହେଲା ବୋଲି ଲେଖିଲେନି final report ଦେଲେନି
last ଅଛି, my lord. Last page.
oh achha that the mediation between the parties was unsuccessful as the informant Lakshmi Priya Mishra did not appear. ହେଲା କଣ ଅଛି allegation?
498, my lord.
The husband
His husband.
493-506-379. The petitioner, along with two friends, they gone to the informant's house and assaulted brutally, my lord, to her and her father and mother. That's a, they received injury, my lord. All of them. That informant received 3 injuries and 3 simple injuries, 1 grievous injury, my lord. And their father and mother, they also received 3 laceration wound, 3 simple injury, and
well, make it first or second half.
My lord.
The petitioner is apprehending arrest in connection with such and such case. It is alleged that the petitioner had married the opposite party. Subsequently, dissension arose as the petitioner allegedly subjected her to physical and mental torture. On the date of occurrence, the petitioner, along with his friends, went to the house of the informant, went to the father's house of the informant, being drunk and severely assaulted the informant as well as her father, causing grievous injuries. Yeah. Learned State Council has opposed the prayer for bail by submitting that the informant and her father sustained.
Father and mother also.
Informant and her parents sustained
yes.
several injuries, including grievous injuries. First or second half.
Parity, lots of director.
Parity, because the allegations are directed against you.
Since initial she was in this court one. Subsequently, never appear.
Initial se appear kale boli dori ke apan ko appear kale kan apan full badi thanta.
No, my lord. Court appear kari mediation ko job kari. Mediation ko appear kale tabra asile ne jani.
Last. But in that order, some mistake were there.
ये तो 664
664
yes
ସେଥିରେ ଟିକେ ଅଫେନ୍ସ ଗୁଡାକ ଟିକେ ଭୁଲ ଲେଖା ହେଇଛି ବୋଲି ନହେଲେ କେସ୍ ନମ୍ବର ଆଉ ଇଏ ସବୁ ସମାନ ଅଛି ଫାର୍ଷ୍ଟ ପେଜ ୟୋର ଲର୍ଡସିପ୍ ଫାଇଣ୍ଡ ଦିସ୍
no
there is 307 allegation
but ଏଇଥିରେ ଅଫେନ୍ସ ଟା ଭୁଲ ଅଛି ତ ହଁ ହେଇଛି କଣ କରାଯିବ
ସେଟା ମୁଁ କହୁନି ଏଥିରେ ଆଉ ସେଇ ସେମ୍ ଅର୍ଡର ବେଳେ ଆଉ ଏଇ ଅଫେନ୍ସ ଟା ରହିବ
what do you say
my lord first or second order has been granted
खाली ऑफेंस वाला को चेंज कर दो हां ठीक
item 48 may I be the lordship my lord typographical error order dated 12/6/24 my lord ମୁଁ ପିଟିସନ ତଳେ ମୁଁ ଅର୍ଡର ଟାରେ ରାଉଣ୍ଡ ଭୁଲ ଅଛି ଫାର୍ଷ୍ଟ ରେ ମୋ ନାଁଟା ଲେଖା ହେଇନି ଏସକେ ସାମନ୍ତରାୟ ଲେଖା ହେଇଛି ଏସସି ମେକଅପ୍ ହବ ନମ୍ବର 1 ନମ୍ବର 2 my lord ତା ସିରିयल ନମ୍ବର 3 ଅର୍ଡର ନମ୍ବର 3 पारा 3 जीआर केस नंबर 1181 लिखा है 181 हबो नंबर 2 नंबर 3 माइलर जेहेतु एटा पोस्को एक्ट लागिची हजूर लिखि दैछन्ती फर्स्ट आवर सेकंड आवर सेही कोर्ट रे आगे मूव हबो बेलटा गोटाई कोर्ट जेहेतु पोस्को एक्ट अछि एडिशनल सेशन जज कम स्पेशल जज सेही कोर्ट रे आगे मूव हबो आ तार सेकंड आवर ता नाही सेटा आगे कर सेकंड पेज लिखा है फर्स्ट और सेकंड आवर
since there are multiple errors in the order dated 12/6/2024, comma the same is recalled. Matter is heard again. इतने सी जो एडवोकेट को नाटा इसके सामने लगे चले इसके मेकअप लिखने से करेक्शन होगा नहीं इटा नुआ ऑर्डर पास है ना कौन इटा रिकॉल है ना कौन पैराग्राफ 3 टा जहाँ अच्छी से लिखिए पैराग्राफ 3 एक्सेप्शन सीआर केस नंबर टा 181 में पैराग्राफ 4 ठीक है छी Paragraph 5 रे लिखंतु nevertheless considering the fact that the case has been stalled because of non-appearance of the petitioner while not being inclined to grant anticipatory bail, the bail appeal is disposed of, granting liberty to the petitioner to surrender before the court in session over the matter and to move for bail, which shall be disposed of on the same day. Yes.
My lord. Okay. Deep law plus.
Item 49.
On behalf of SK Rautrasi, the FIR registered under section 379 of IPC lordship, theft of a bike lordship. In the meantime, co-accused has already used on later.
Yes, madam.
Same order.
Bullet has been recovered from
Same order.
other courts. Item 50.
May I please your lordship, madam? 50 आज्ञा CRLM रे nomenclature टा order रे भूल जाई छी ए BLFL जगह रे BLFL हे जाई छी सर
In paragraph 3, instead of BLAPL, the word ABLAPL be mentioned. Yes.
ना सर ए BLFL ठीक होती BLFL टा भूल जाई छी BLFL टा भूल लिखा छी सेटा ए BLFL टॉप माने आज्ञा
तो से कोई BLAPL जगह रे ABLAPL लिखा हो तो
ना ए BLFL जगह रे BLFL लिखा छी सर ए BLFL जगह रे BLFL लिखा छी nomenclature order dated 15/5/24 रे
तो मु तो से कहूची ना आगे BLAPL जगह रे ABLAPL लिखा हो तो अपन काउंटिंग ABLAPL नंबर 1084 of 2024 is restored to file जो लिखा है BLAPL लिखा है ABLAPL कर दो. Yes.
So item number 11.
Matter relating to selection of Shiksha Act of the year 2011, and they have challenged the resolution made in the year 11. And in the meantime, that has become infructuous.
Dismissed as infructuous.
Sir, item number 12.
Whose was the petitioner? Item 12. Weekly, no, not weekly. This is weekly supplementary. Item 12, anybody? Disposed of? Yes.
All interim order stand off.
Automatically disposed of.
Name of Mr. Udgata.
Yeah, इतना mention करिए से तो तब order से जहाँ ये रहला और कुछ नहीं.
ये दिलाड़ो
Disposed of सब ओकलम का नाम लिखो. Opposite party रे एसन इन्हों सुधरता है लिखो.
Item number 14.
Taken up next week.
Yes.
Kindly taken up next week. Not difficult.
All right, next week.
So item number 21.
This matter may be urgent because your lordship has had this similar matter yesterday. Today, 28 ରଖିଛନ୍ତି 28 ପରେ ଏଇଟା ଆସ କାନା ସେ ଅର୍ଡରଟା ଇମ୍ପ୍ଲିମେଣ୍ଟେସନ ପାଇଁ ମୁଁ ଏଟା ଦେଇଛି ତେଲ ଚ୍ୟାଲେଞ୍ଜ ଏଠି ଅଛି.
अच्छा. So list this matter after auto 20 ପରେ ଗୋଟେ ଆଉ date
27th August. 27th August.
27th August.
So item number 37.
May please claim for 1 week capital.
1 week after as paid for.
So item number 42.
My lord, the petitioners before your lordship is in the third round.
Yes.
Offense under section 20B Roman 2C 25 and 29 of the NDPS Act.
Yes.
Your lordship had directed expeditious conclusion of trial within a period of 4 months on 14/11/23. And a report has been called for. The report is at flag Z.
Eleven witnesses have already been examined.
Yes. Up to 22, I am
so it's progressing reasonably fast.
But my custody is in since 21, madam.
कौन करेगा?
Only ambiguity in that.
Regular bill भी पर था
89 kg.
कौन कहिए
किसी कौन तो नहीं
मोहकिला आगे ठिया करची तो किसी तो कहिए
किसी कौन तो नहीं बेले किसी को न कोई बेटा ही बोलो. Is this matter 1 week after?
अब गोटे दिन सर Jack. Owner गाड़ी रे present थिला. I am the driver. My lord, it is not that I have taken the vehicle. The owner was escorting and owner was present in the vehicle. And I am a poorly paid driver. My lord. And I'm more than 3 years I'm in custody, madam.
Hey, the trial is progressing quite fast.
As your lordship please.
1 week after. Hola.
Weekly list item number 11.
Kalito, kai lagi? Oh, Kalito. Item 11, yes, state.
Yes. My learned friend Mr. Mishra had appeared, though he had not filed any. He took time to file objection to the permission petition.
That means there is no objection.
Because state was not implemented as a party and the judgment has been against the state. The second appeal has been filed.
What is the delay?
Delay is
They have taken time twice. What is the delay?
the delay is about 4 years.
Yes, but what is the judgment? I mean, the suit for
declaration.
Declaration. So, yes, sir.
Sir.
What is the matter? Let us consider whether there is an arguable case made out or not.
ठीक है, pass over it.
All right, pass over.
Item number 12.
Praying for a password for the day.
Pass over.
Item number 13.
13, my lord, I am appearing for the appellants. My lord, we have filed IA number 506 of 24 for substitution of R2.
IA number 506 of 24 for substitution of R2.
My lord.
Then
IA number?
The IA number 653 for
Yes.
R1 who passed away on
Yes.
this day. So we'll take up one by one.
My lord.
Okay.
Your lordship, for respondent now in this case, for respondent number 1, I am appearing, but my name has not been reflected. Your lordship,
Respondent number 1. Respondent number 1 has passed away?
passed away for his legal heirs.
For his legal heirs, okay. But has he,
appearance already-
no, was any order for substitution passed? I don't think so.
My lord, notice was issued, my lord.
Oh.
Appearance has been filed.
I'll
on
allow it.
21st of August.
All right, I'll allow it. You will be respondent, you will be substituted.
Yes.
IA कहते हैं ना बेटा, IA 653 ने?
For respondent number 1, my lord, IA 653 of 23.
Yes. This is an application for substitution of, इधर को delay अछि?
No, my lord.
Substitution of respondent number 1, Ramesh Chandra Das, who died on 13/4/2023, leaving behind his widow and 3 daughters as his legal heirs. It is stated that this right to sue survives against the legal heirs of the deceased. As such, they are necessary parties to the appeal. In such view of the matter, I am inclined to allow the prayer for substitution. The LRs of the deceased respondent number 1, as per schedule, be impleted as respondent numbers 1A to 1D. Consolidated cost title be consolidated cost title last लिखी हो तो तब लिखी जाता है. Consolidated cost title be filed by tomorrow.
My lord.
Consolidated cost title be filed tomorrow. Since The LRs of the respondents have already entered appearance through your good name, sir?
Sagar Ranjan Panigrahi.
Sri S.K. Panigrahi. Let a copy of the appeal memo be served upon him. Yes. Well, how would you go? 505?
506, my lord.
506. This is in time.
Yes, my lord.
Respondent number 2 कर देबे
Respondent number 2.
जहाँ लिखा है सेटा आरटर जा डाकली सेटा लिखि देबे consolidated be filed by tomorrow.
My lord.
इधर की appear करना थी.
No, my lord.
You are not appearing for respondent number 2.
No, your lord.
But then we'll have to issue notice.
No, my lord.
Issue notice to the newly pleaded respondents by registered post with 80. Returnable within 4 weeks. Requisites be filed within 3 working days. Please this matter.
In the week mentioned
September
23rd September.
23rd September.
Your lordship, I just pray for service of copies with regard to IA 653, IA 705 and IA 506.
IA 653 notice was issued.
But the respondents, the legal heirs of the respondents, they only received the notice, but no petition has been received.
All right, you serve a copy. What is the meaning of it? Because already I have allowed. Anyway, you receive a copy. Serve him a copy. And what? Anything else?
And IA 705 of 2024.
What is this IA?
IA, my lord, we had filed for extension of interim order.
705.
Yes, my lord.
That is not right.
Interim order was passed regarding not to create any third party interest, my lord.
Flag? Sir, 505 no, 705.
705, my lord, at flag Q.
Sir, 505. That is IA 505. Got it? It's IA 5705. I mean 505. 705 क्या लिखा है?
70.
See, noting रे भूल लिखा है. It is 505.
Lordship.
All right. Interim order to continue. Yes.
Obliged.
Item 14.
My lord, on the last occasion, that is 9/7/2024, the lordship passed the order to remove the defect within 3 days peremptorily, my lord. And soon after, I applied for the certified copy, and I could not file because I got the certified copy on 19, my lord. Kindly accept this.
Okay. Dylan. Yeah, when did you apply?
10.
When was this order passed?
On 9/7/2024.
No, this is the dismissal of this appeal.
Yes, ma'am.
Yes, then?
No, dismissal of my lord. Yes, RSA, ma'am.
So that it has to be taken on record or?
Yes, ma'am.
Yes. Learned counsel for the petitioner files copy of the order dated, certified copy of this order dated 9/1/2020, whereby the appeal is an earlier order, isn't it?
Yes, ma'am.
I don't get it. This was dismissed as per order dated 19/12/2019.
My lord, kindly, I am placing the matter, my lord.
Yes.
This same appeal has been filed for the restoration of RSA 368 of 2017, which was
That was dismissed in
9/1/2020.
19/12/2019.
And 19/12/2020, Honorable Court directed that.
So that is because of the peremptory order.
Yes, ma'am.
So peremptory order, so it doesn't come to the bench. It has to be
Yes.
dismissed by the by the additional deputy registrar.
Yes, ma'am.
All right. Honestly, then counsel for certified copy of order dated 9/1/2020 of the ADR bracket J and E, whereby the second appeal being RSA number 368 of 2017 was dismissed for non-compliance of peremptory order. The certified copy be kept on record. Put up this matter after SR.
Oblique.
Item number 16.
Item number 16, I am for the respondent number 2 to 14 minutes.
Your Lordship, item number 16, there is a noting that respondent number 1 has died and we have not taken steps for substitution. Your Lordship, the respondent number 1 had died during the pendency of the RFA and the legal heirs are already on record as respondent number 2 and 3, Your Lordship. We're filing a memo.
Yes, what do you say? Learned counsel for the petitioner by filing a memo submits that the LRs of the deceased respondent number 1, who died during pendency of the first appeal are already on record in the form of respondent number 2 and 3. Learned counsel appearing for respondent number 2 and 3 does not dispute such submission. As such, no substitution is necessary. Then,
Lordship, IA number 387 of 2023 was filed for condoning the delay and the notice
was already issued.
And
I have received the delay.
Delay
1 month, 10 days.
1 month?
10 days, Your Lordship.
39 days.
Yes,
Yes, yes.
What do you say?
Your Lordship may condone.
This is an application for condonation of delay. He submitted as appellant number 1, who was looking after the appeal on behalf of the other appellants. Suddenly fell ill and had to remain under treatment for more than 2 months. So he, after recovering from his illness, he contacted his advocate and thereafter the appeal was drafted and filed. In the process, there has been delay of 39 days, from which, according to the appellant, is due to bona fide reasons. Learned counsel appearing for the respondents has no serious objection to the appeal being admitted, to the delay being condoned. Considering the submissions and the grounds raised, I am inclined to condone the delay in filing of the appeal. Subject to payment of cost of kete?
As your lord.
500 rupees to be paid to the counsel for respondent numbers 3 and 4. The receipt be filed within a week. Yes.
Your Lordship, IA number 424 of 2024 has been filed for deletion of the name of appellant number 3, Your Lordship.
Why?
Thus, she has been inadvertently added as party, Your Lordship.
She was not a party in the court below. All right.
Oh, Your Lordship, she was never a party to the proceedings in trial court as well as the first appellate.
Considering the submissions, the
Copy
name of,
has not been sought to us.
I'm sorry. I'm sorry.
considering the submissions, the name of appellant number 3 is deleted from the appeal at the risk of the appellant.
Obliged.
This has to come for admission, I believe.
Yes, sir.
Let this matter. 2023 matter. Okay, September.
The week commencing 23rd September.
In the week commencing 23rd September.
Sorry to intervene. The urgency is, my lord, they are interfering in my position. So therefore, your lordship may take up this matter to next week.
Well, next week for admission. Yes.
Obliged.
I don't know 20.
Shut up. Pass over.
I don't know 22.
And for the respondents. Some of the respondents and them.
This is for admission.
Admission.
Number 22 may request for pass over for the day.
22.
22. On behalf of Mr. Senior Counsel, Mr. SP.
In this case, I have not received a copy of the appeal memo.
No, it has not. It has come for admission. Let it be admitted first.
Only on questionable limitation it has been.
Only on limitation.
Actually, limitation we have entered appearance.
Limitation delay has been condoned.
Delay has been condoned.
Yes.
So appeal memo tare upon admission case apan kon koyar achi. Let us hear the appellant. If the court decides not to admit, end of the matter. Only if the court decides to admit, then only notice will be served on him. So pass over for the day.
Friday रख दो.
Friday.
Let me qualify.
Senior Mr. Bhuya
We had appeared and it was practically heard on before Honorable Justice Das. So it was decided that it will be disposed of at the stage of admission if subject to what your lordship. So if
on that day I will hear you. I am not saying that I will not hear you.
Can it be on Friday? Mr. Bhuya is not there. Friday.
All right. Friday khali mark kar dita. Pass over. Friday will mark kar dita.
much of
So the bunch of matters.
Four matters. But there were suit different counterclaims. 4 first appeals, 4 second appeals.
Okay. So common judgment.
Common judgment.
Yes.
Item 23. May please, Your Lordship. At the first occasion, the second appeal was dismissed. Thereafter, we filed a review petition, and the second appeal was restored to the files. The review was allowed and restored to file. Challenging is the present respondents have moved to the Honorable Supreme Court. The date is tomorrow, my lord.
Supreme Court?
Yes, Your Lordship.
Next week yeah,
it will be better.
It is submitted that the matter before the Supreme Court is posted to tomorrow.
Yes, Your Lordship.
Hence, is this matter next week? We commencing with that. No, next week.
Item 24.
But the respondent.
Yes.
Last order, your lordships will see that last week appellant was not.
There was no appearance.
There was no appearance then.
But I cannot pass any order today. Whatever order I'll pass it on Friday. If nobody appears, because this is for the entire week. If nobody appears, then on Friday I may pass some order. Yes. Pass over.
Item 25. May please, Your Lordship. If Your Lordship kindly looks at the last order.
In item 25, I am appearing for the respondent by Okalatana may be accepted.
Anyway, this is for interference for the respondent. After obtaining no objection from the previous counsel, the Vakalatnama be kept on record. The name of Sri Panigrahi be reflected in the cause list, deleting the name of the previous counsel. Yes.
Well, if you also kindly looks at the order dated 7/2/2024, asked by a coordinate bench in this matter.
Yes.
Yes. My lord, this is a matrimonial dispute. The husband, the appellant is the husband. He filed a CP, civil proceeding, to declare the marriage as null and void under section 11 of the Hindu Marriage Act. And in the alternative, if the marriage is found to be subsisting, then to dissolve the marriage, my lord. The meantime, my lord, from the first wife, that the respondents and the appellant's wedlock, there is a son of 22 years. In the meantime, the husband is married to some other girl, and they are having 2 kids. One is 17 years and one is 19 years. So, Your Lordship, if the marriage is allowed to continue, then no one is going to be get benefited. So, the Honorable Coordinate Bench thought it proper to call the parties and fix a amount maintenance so that this respondent can get something and the marriage can be dissolved.
Why not you do this exercise before the mediation center? Yes. On that basis, if there's a consent,
yes,
on
the amount can be, yes, marriage can be dissolved.
In course of hearing, it is stated at the bar that the apparent husband married another lady, and out of such marriage, 2 children have been born. Stop.
That is their original pleadings.
Yes.
That is already on record, madam.
According to the parties, their well-wishers have advised them to settle the matter amicably. In such view of the matter, let the records be placed before the coordinator Odisha High Court Mediation Center, who shall do the needful so and so for those. Parties are requested to appear before the mediator pursuant to notice. Let this matter go to master date there.
In the week commencing 9th September.
In the week commencing 9th September.
Highly obliged. I don't know, 26.
May I please, Your Honor? It's for admission of the appeal. Last occasion, your lordship opined, but they didn't agree that there is no chance of mediation. The fact of the case is that the present appellant is the husband. There is a matrimonial dispute before the Learned Judge Family Court in CP number 593 of 2004, which has been ended in by compromise. Divorce has been the maintenance has been allowed for ₹3,000, and undoubtedly the appellant has been paid till date without fail. The respondent filed a proceeding before the Learned Civil Judge Senior Division for variance of the order which has been ended in compromise under section 25 of Hindu Adoption and Maintenance, because the original proceeding is under Hindu Adoption and Maintenance Act. The Learned Civil Judge in misconstrued take it the matter as for section 25 of Hindu Marriage Act and varied the order. Challenging that order, I preferred an appeal before the Honorable Court, and ultimately the Honorable Court hold that as because the Civil Judge Senior Division has been passed the order, it has to be appealed before the Learned District Judge. That order which has been passed this Honorable Court in my absence during COVID period. I didn't know about the order of this Honorable Court. When I got the order, I approached the Learned District ADJ before the Learned ADJ Attaghat, who dismissed my appeal only on the ground of the limitations. Hence, this appeal before your honor. My respectable submission, the Learned Civil Judge, both the orders is per se illegal and arbitrary, as because the Learned Civil Judge has misconstrued the section 25 of Hindu Adoption and Maintenance Act as the section 25 of Hindu Marriage Act and passed the order. And vis-a-vis the Learned ADJ, without condoning the delay, dismiss my appeal. That is the sole and substance of my argument, that both the order of the Learned Civil Judge as well as Learned ADJ is vitiated by law. And furthermore, your lordship, section 25 of Hindu Adoption and Maintenance Act, there is no appeal provision, and it is carried out by Hindu Marriage Act. Hindu Marriage Act. It is a decree, as it is a decree. So the appeal is maintainable before this Honorable Court. And the question of law I formulated that the court which original court, your lordship, kindly have a glance at the original court's order itself. That is annexure 1.
No, let's see what is the question of law you have framed.
Question of law, your lordship, it's
because we will hear this matter finally.
Yes, your lordship, because my Learned
Formally, I may frame a question, but I'll hear it finally today. Yes. Today, or if you're not ready, maybe next week. Kintu it will be completed.
Yes, your lordship.
So, which ground are you suggesting?
Your lordship, that is that is page 8. Page 8, your lordship. Whether the Learned Appellate Court justified dismissing the petition at section 5 of Limitation Act without condoning preferring the appeal, consequently dismissing the matrimonial appeal.
A or B hoga to?
A or B.
A or B re admit kar do chi hearing karo to final karo. LCR is necessary? I don't think.
Not necessary. It is small.
Sri J. Bhuya, Learned Counsel for the appellant, considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law, A and B. A and B. Since the respondent has already entered appearance, no notice need be issued. You have a copy of the appeal memo?
Yes, I have one. Yes.
A copy of the appeal memo has also been served upon him earlier. Both parties agree that the matter can be finally disposed of at this stage without calling for the LCR. কোনটা আজি করিবে না কোন করিবে
এদিকে তো খালি দেখিয়ে দেবি জাজমেন্ট
আজি শুনলো না শুন Yes,
lordship, kindly have a class to annexure 1.
Annexure 1
is the judgment of
the trial court order.
Yes, your lordship. This is, your lordship, opening sentence of the petition order is that this is an application under section 25 of Hindu Adoption and Maintenance Act 1956 filed by the petitioner for alteration of decree passed on 799 directed to OP to pay 7,000 per month towards maintenance in view of the changed circumstances. This is her application.
Yes.
Straight away, your lordship, I will take to issue number, that is page 5, the Land and Royal Court's observation, that is issue number A and B. Operating part is 7, your lordship.
What page kete?
Page 12, your lordship. That is issue number A and B. Internal page 4, that is judgments internal page 5. Your lordship, para 7. Taking into account their variable condition, it is worthwhile to mention that admittedly a consent decree operates as an estoppel, but it is essential to see if same operate as an estoppel in case of such a nature where enhanced maintenance has been claimed. In this regard, it is essential to pursue section 25 of Hindu Marriage Act, and it reads as follows. Then write down section 25 and para it, next page.
Please it.
From a bare perusal section 25(2) of the Act, it is clear that the section would apply only if there is a change of circumstances of either party at any time after an order has been made under section 25(1). This can be at the instance of either party, whereby the court can vary, modify, rescind any such order of maintenance. The provisions of laid down section 25(1) of Hindu Marriage Act will show that the power to grant alimony or maintenance is not only at the time of passing of a decree, but it can be at any subsequent thereto. Section 25 entails a maintenance holder to claim enhanced rate maintenance if there is material change in circumstances justifying such alteration. The section will certainly apply to cases where the quotation of questions of maintenance has already been fixed either by a decree of a court or by virtue of agreement between the parties. A decree of court referred to section 25 is wide enough to make consent or compromise decree, as there is no restriction with respect to nature of a decree. The very intention of or object of section 25 is to benefit the maintenance holder, thereby permit her to plead higher rate of maintenance on altered and changed circumstances. Since the provision of section 25 of the Act is applicable to any case where the fixation of one term of maintenance was made either before or after the commencement of this Act, the decision relied by the land council, the respondent cited so and so, is not applicable to fact and circumstance. Moreover, the said decision hours passed in the arbitration proceeding where the subject matter of the application passed in the arbitration with subject matter challenge, hence the fact and circumstance the said case are hardly applicable to so. So section then issue number C and D, he played for construction of house amounting of rupees 2 lakhs. That is and ultimately, your lordship, the page internal page 9, the order of the Land Civil Judge. The proceeding under section 25 of Hindu Maintenance Act.
Hindu Maintenance Act कौन?
से लिखी
से Hindu Adoption and Maintenance.
Adoption and Maintenance. ভিতরে লিখলে section 25 of Hindu Marriage Act. Ultimately, she holds that the Hindu Adoption and Hindu Maintenance Act is allowed in part and contest against the respondent. He is directed to pay rupees 5,000 per month as maintenance is totally from the date of this.
So, Mr. Bhuya, tell me, if the court, any court, including the High Court and the Supreme Court also, make a wrong reference to
law,
a law.
That is nomenclature not a word. That judgment is.
So, Hindu Adoption and Maintenance wrongly, I have mentioned it as Hindu Marriage Act. But the intention has to be gathered. What she claims maintenance.
And maintenance, enhanced rate maintenance.
Enhanced rate of maintenance.
Yes, your lord.
So your main plea is that she is stopped because of the earlier compromise decree.
Compromise.
You can argue on that.
Your lord.
That may be your plank of argument.
Yes, sir. Yes. The section 25 says that can be change of circumstances. I bow down to that. And the agreement be. So on only one point, I probably out of court, I will say, 5,000 daba we agree. I am not standing on the way because she is my wife. on my record also she is standing as my wife. I am retired right now from my service. So 5,000 from the Ajika date ru jodi 5,000 hejibo kichhi bi mu setire bi manna karibeni. But the date of application hegile belku that 2,000 is staring against me. 2000.
So the date of application kebe?
Date of application hoche 2014. Around 2 lakhs rupees I have to pay. That is the
You come down. You come down. It can be settled immediately. Prospectively, hobo past area rochi area ru kichi debe. 10 ବର୍ଷର area dala belku agya will it not be harsh?
Lordship, he married in 72. Only 2 years they enjoy and they kept another lady. Now he is residing in his parents' house since long. बर्तन जो एज रे तार जहाँ कॉम्प्लिकेशन तार जो बर्तन
नहीं सी तो he is agreeable to pay. He is not saying that he will not pay. He says that he will pay. He is not referring to the arrears. I am saying that you have to pay arrears. Yes. Not that you will not pay arrears.
He expressed honestly he is my wife. Till 2015 ରୁ कोविड गला केमिति सस्टेन करछि
आगे सेटा छाड़ंतु आगे सुनो से prospectively 5,000 rupees देबे every month अपन every month तो अबे
हां every month
जो एरिया अछि एरिया ता 10 वर्ष रे एरिया रहउछि से एरिया ता तो किछि आपण ये करंतु जदी कमेली से बाकी तक दबे
सेटा एडी डिसाइड कर दिया को बेसिक के बेट
करबा एरिया एकना डिपॉजिट करबा डिपॉजिट आपण केते होछि एरिया ता केते होछि हिसाब करंतु
2 years रिलैक्स कर दिया जाता है 15 हले 18 तो दंछि
हां that is not a bad suggestion. He's saying deduct to but he's saying from that you pay from 2018 onwards.
Lordship, I have challenged the judgment on in the year 2018 before this honorable court.
No, 2008 এই কোর্ট ইসনা আসলে
20 রে this court dismissed my
এই কোর্ট को 18 রে.
So date of application is 2014.
Yes.
Correct. When was the decree passed?
Decree, your lordship, that is so 16 to 2015.
Correct. Even if we accept this as the date of payment,
yes,
Jadi as accepting that all other applications have been or appeals have been rejected, there is nothing to interfere, then you will be bound to pay from 2015. Here he can come.
Lordship, ମୁଁ ତା ସଜେସନ ଆଲି ମୁଁ ଗୋଟେ ସଜେସନ ଦଉଛି ମୁଁ ତାଙ୍କର ସଜେସନ କିଛି ପାଇନି ମୁଁ ଜଷ୍ଟ ଗୋଟେ ସଜେସନ ଦଉଛି 2 years ରିଲାକ୍ସ କରି ଦିଆ ଯାଉ ଏଇ କଥା
ଭଲ କଥା nothing bad.
18 ରୁ ଦବା ପାଇଁ କହୁଛୁ 2018 ପରଠୁ ଦେବି ଆଉ 6 years ପାଇଁ ଦେବି ଆଉ
କଣ କହୁଛନ୍ତି 2018 ରୁ
6,000 per month
6 years କଣ ଓ 18 ରୁ ଆଜି ପର୍ଯ୍ୟନ୍ତ 6 years ମାସକୁ 2,000 ଟଙ୍କା ଲେଖେ
ହଁ
କେତେ ହେଲା
2,000 ଟଙ୍କା ହେଲେ ବର୍ଷକୁ ହଉଛି 24,000 ଟଙ୍କା 24,000 into 6.
So mula type they na say 3,000.
No. I am paying. That is no. Probably my learned senior friend probably not taken instruction properly.
What they have said.
Tell you get ready. Come with a calculation sheet tomorrow. I will dispose of according to that.
Yes, your lord. I have paid till date. I have paid. There is no outstanding. Only that 2,000 rupees I have not paid.
No.
5,000 court
kale. Ichha कहउछने से मते कले कोविड को आगा ता पूर्वरु मो केस
मु जवाब मु देई दोछि रिसिप्ट गुडा को probably my learned senior friend is not properly instructed. That is why total bill गुडा को रखि देई दोछि माने जो गुडा को बैंक रे डिपॉजिट करछि
ताको देखि दंतु आई एम पासिंग इट ओवर
देइथिबा कोन हतरे
डिस्काउंट आई एम पासिंग इट ओवर
ए मंत्र
ना आपण जानन थु जे किन सेम
एटा नियंतु एटा टोटल मंत्र मु गोटे सेट टे भी जेरॉक्स करके आपन
को ईयर कोन हटात के मु देखि को ईयर
आई एम पासिंग
नेक्स्ट लॉट्स ऑफ पुट टेकन अप दिस मैटर नेक्स्ट वीक
heard and part please this matter next week both of you please take instruction if necessary file a joint application I'll dispose of
yes lords मु एटा गोटे जेरॉक्स करके
joint application करंतु yes he is also willing to sacrifice some amount you also
yes
agreeing to pay that area amount matter is over
I will
instead कौन decide हो जानि पउ
जे देइथे सेटा डिनाइड करिया
नहीं अपन देखि दंतु you take instruction from the client
पचा दो
all right yes
item 27 interim order to continue
27
हमको दे appellant
yes
the second appeal has been filed against a reversing judgment.
The court fee not paid?
So the court fee has been paid.
Has been paid?
Okay.
You filed a petition for exemption.
Exemption. Huh? Good.
Since the yearly income is less than 1 lakh, but filed a petition for exemption of court fee.   .
1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . 1 . Annexure 1 by A. No, we let the state take instruction.
File the income certificate.
So income certificate ठीक क्यों भूला मुझे जानू?
Also, I am appealing for the caveator. I have instruction to file objection to that because he has landed properties. The appellant is having landed properties.
I am asking the state to find out whether
Yes,
this document is genuine or not.
Mala.
देखा लोग किन लग रहा है? 7. Yes. Then IA 187 of 2024. London State Council shall take instructions with regard to the income certificate enclosed to this application. List this matter.
Then the week commencing 12th August.
In the week commencing 12th August. In the meantime, the caveator may also file objection if so advised to the petition for exemption of exemption. Yes.
My lord, execution case is also pending. So the execute korike possession ta then prejudice.
मैं अपन फाइल कर जिंदा है till the next date the execution case shall not proceed till the next date.
Much obliged.
Item 28.
28
pages. Well, this is against the confirming judgment. Here the peculiarity of the case is that the appellant and the respondent number 4 are brothers and sisters, my lord. They were
Steel Authority of India like
my lord. Respondent number 1, 2 and 3
is Gyanendra
Nanda. Appellant is the Gyanendra Nanda. He is the brother of the respondent number 4.
Yes.
And here the factual matrix is that yes. The father of the plaintiff, here the appellant is the plaintiff, and the respondent number 4 was the defendant number 4. The father of the defendant number 4 and the plaintiff was working in the Steel Authority of India, Rourkela, RSP. He was working in RSP. Subsequently, he was discharged from his service on the ground of disability. Thereafter, the defendant number 4 got the job on the basis of compassionate ground, my lord. So by that time, an agreement was there between the defendant number 4, father of the plaintiff, and the Steel Authority of India. Tripartite agreement was there that the defendant number 4 will disburse 1/3 of the salary to the petitioner, who was by then 10 years old and he is physically handicapped. The appellant and the plaintiff are physically handicapped, 51% handicapped.
Who the appellant is also handicapped?
Appellant is the handicapped only, my lord.
And his father is also
father, due to his ailing age, old age, he got discharged from his service. And on compassionate ground, the defendant number 4 got
his daughter got up.
My lord.
Yes.
And before the service was provided to her, it was a agreement was there, tripartite agreement was there. The father and the sister, that is the defendant number 4, and the Steel Authority of India Limited. They executed an agreement. In that agreement, it was specifically mentioned that 1/3 of the salary that defendant number 4 will give to this plaintiff, because
her brother.
Dependent,
her
brother. That's it. And after her retirement, also the pension and the gratuity, all the retirement benefits, he will share 1/3 of the amount. My lord, the father expired on 1998. The father expired. Thereafter, the defendant number 4 stopped paying anything like some maintenance amount and all. He stopped paying. She stopped paying. Thereafter, she was paying 1,000 rupees per month for his sustenance. The defendant was staying at defendant 4 was staying at Rourkela. The plaintiff was staying at Hon'Ble district.
Yes.
It is parental law. In 4/1/2006, she completely stopped paying anything. The maintenance amount and all is completely stopped paying. Thereafter, the plaintiff filed the suit for specific performance of the agreement. That agreement which was executed back in 1986.
What are the issues?
Well, issues at page number 39. The issues were framed here. Page number 39, running page 39, inner page 5 of the trial court judgment.
He holds it to not to
well, it's not dismissed in the on the preliminary issue, lack of jurisdiction, because the suit was.
So what is wrong in it? Rourkela
Agreement is nowhere mentioned that agreement was done in Rourkela, and it section 20 of the CPC says the plaintiff has liberty to file the suit where he resides or the company resides, and without following that, the suit was dismissed, my lord. That is my case. And also if your lordship kindly turns to page number 44, it was dismissed on preliminary issue, your lordship. Page 44.
Yes.
So it is refer that therefore, page 43, it starts last paragraph. Therefore, by mere residing within the territorial jurisdiction of this court will not confer power upon this court to entertain the suit, more particularly in the absence of the written agreement. So on that preliminary issue, the suit was dismissed, and the First Appellate Court confirmed the findings. No such discussion was there. Confirmed the findings, your lordship.
So what is wrong in it?
Well, section 20 of CPC was not followed with.
Here, the agreement was executed at Rourkela. Agreement is to be made from Rourkela.
My lord, that there is a question, and the learned trial court also said that where that agreement was executed, it is nowhere mentioned, my lord.
Why?
From the documents also and all, that is not there.
Where is that agreement? Do you have a copy?
My lord, that is Exhibit 1, but I don't have the copy.
Is the LCR Ashrathi or Exhibit 1 कहले कौन होगा? If you have a copy, I could have seen.
My lord,
I don't find it.
The lordship calls for the LCR, and on the next date also it can be.
No.
Or else I'll try to obtain the copy. Agreement.
Agreement was submitted before the sale authorities on 31/10/1986. Sale authorities are in Rourkela, not in Hon'Ble.
Well, defendant was in Hon'Ble.
Defendant number 4 was serving as senior attendant of the general ward of Ispat Hospital, Rourkela.
Yes, yes.
Disturbances also took place at Rourkela. Defendant number 4 draws salary from Rourkela.
Well, the
plaintiff was residing at Rourkela. So which part of the cause of action arose?
Plaintiff was residing on Hon'Ble, my lord. That is the material source.
Plaintiff was also residing at Rourkela.
For a short period of time, he was residing at Rourkela. Thereafter, he moved to Hon'Ble. This is also on records, my lord.
Difficult case.
My lord. Yes.
Very, very difficult case.
Or else the trial court should have returned the plaintiff and permitted the plaintiff to file it in the appropriate forum. That also.
Why? Is it mandatory?
If lordship kindly keeps it to tomorrow, my lord.
All right, pass over.
Obliged.
Item 29.
So yes, reversing judgment. Plaintiff is the appellant before worship.
Yes.
He filed suit for declaration of right title interest on the basis of a registered sale deed. In the sale deed, there is a discrepancy with regard to the plot number. For the khata number, everything is all right. The boundary is same. Description of everything is correct. Trial court decreed the suit that the boundary has to prevail, and the discrepancy in the plot will not be ground to reject.
No, what was the cause of action?
Cause of action, the defendant or one of the defendant tried to disturb the possession in spite of the fact his ancestors has already sold the property in favor of the plaintiff. That is why the cause of action arose. The reversal of the judgment is only on the ground that description is not correct. I have taken the ground, if you also kindly look at page 17. And they also admit in evidence. A, B, C, these three are the main grounds in fact.
A and B. A and B will do?
Sir?
A and B will do?
Sir, A, B and D will be better.
All right. Let's see. SP Mishra, let's see, counsel with, yes, your name I'm forgetting. What is your name?
GN Porida, Your Lordship.
JN Porida. Then counsel for the appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. A, B, or D, correct? Page 17. Issue notice to the respondents by registered post with AD. Returnable within 4 weeks. Requisites be filed within 3 working days. Call for the LCR. List this matter after service of notice. List this matter go to September.
We come in 30th September.
In the week commencing 30th September. Yes.
The interim status could be maintained.
आइए कितना आइए 283 तो
F5.
आइए is 283.
Yes.
Status quo with regard to the suit property shall be maintained to the next date.
Item number 30.
The item 22, in fact, there are 5 appeals. Four appeals. First over, out of same judgment. Only the proper substantial question of law I'll give tomorrow. I should consider it.
I have kept it to Friday.
Friday, give it to Friday.
Friday because Mr. Bhuya mentioned that.
There actually, the other side has got nothing.
They have nothing to say, but since earlier an order was passed, that it will be disposed of at this stage. So that is why I wanted their presence. Otherwise, Friday as well. Yes. Item kitne?
Item 30.
Item 30.
May I please, Your Lordship? This is a second appeal against the first appeal was dismissed on ground of limitation.
Confirming? Oh, well, on limitation. Okay.
For delay of 1330 days.
Let us see the first appellate court's order.
Lordship may come to page 33.
33.
The present appeal is preferred after 1330 days. The medical certificate is issued on.
Sir, you are reading from which place? 33.
Page 33. Annexed 2.
In my, there is some discrepancy with regard to the page number. Where is the petition duty RMAG?
Again.
Yes.
That is 32, my lord. Para 6. Next page, my lord.
Okay. Yes.
The present appeal is preferred after 1330 days. To stop, the medical certificate is issued on 6/9/2023 in favor of the appellant, in which the doctor has written that she was undergoing physiotherapy treatment on such and such date. The main ground taken in the appeal memo is that the learned trial court should not have framed issues and passed judgment as if it was a contested one, in the absence of WS of the sole defendant. It is alleged in the appeal memo that after getting the decree, the respondent has occupied a 0.15 decimal of land out of such plot belonging to present appellant, which was not the subject matter of the suit. So far as the encroachment of the portion of the land belonging to the appellant is concerned, it gives rise to a separate cause of action, and as such, judgment is not decided on the land of the appellant allegedly encroached by the respondent. Thereafter, my lord, since the appellant has not shown sufficient cause for not preferring the appeal for about 4 years, admittedly, the appellant had also not appeared in the suit, knowing that she has no connection with the suit land involved in the suit. For the foregoing reasons, I am of the view that the appellant has failed to show sufficient cause ground to condone the delay of about 4 years. Hence, why the petition filed under Section 5 of the Limitation Act is rejected. Thereby, the appeal is disposed of not being admitted. And my lord, the suit is for a permanent injunction and mandatory injunction, that upon if there is any encroachment, you are going to hand over the possession. Now the trial court passed the judgment on 29/11/2019, and a decree was drawn on 7/12/2019, my lord. Now, after which, my lord, the COVID period came. So 2 years should have been excluded in view of the judgment of order of Honorable Supreme Court. Altogether, my lord, as per our calculation.
But you claimed that you were undergoing physiotherapy since 2019.
My lord.
So why should again COVID come into the picture?
My lord, that what I humbly submit, my lord, that the exemption has been given. The Honorable Supreme Court has given exemption
for cause of action arising on or after March 20th.
There another point is that those 2 periods has to be excluded from calculation.
All right, you exclude it. Tell me. Still there is a delay of 2 years. If you exclude that period also, there is a delay of 2 years. Explain. ଆପଣ physiotherapy କରୁଥିଲେ କରନ୍ତୁ ଘରେ ବସି physiotherapy କରନ୍ତୁ ଆଉ କରନ୍ତୁ
ଆଉ ଗୋଟେ ଜିନିଷ I will assist my lord. Lordship may pass over the matter for 2 months.
ସରିଲା ଆଜି ଏଇଟା ପାସ୍ over ହବନି କୁହନ୍ତୁ
ସେଟା ଗୋଟେ ଦିନରେ because it's a land. I was said expert in the trial court. Subsequently, my lord,
so you are a lazy litigant. You are a lazy litigant.
Here
you were set expert. You never filed any petition to set aside or to recall that ex parte order. कौन करा जाए? यार appeal जे तो appeal भी file कर 4 वर्ष पर 2 वर्ष छाड़ दिया जाओ आपनो. कौन करे?
2 years delay.
The only ground that as I find is that she was undergoing a physiotherapy treatment since 1st November 2019 till date.
Because in the trial court, my lord, even the plaintiff has not come in the dock to prove her case, my lord.
See, that is on merit.
That is on merit.
That is on merit. So who stopped you from challenging it in time? Enough.
But my lord, I have preferred the statutory appeal under 96. That may be, my lord, considered ignoring the fact of period of delay, my lord.
Well, your appeal was rejected.
Limitation petition was rejected.
It was never condoned.
But here, my lord, at least, my lord, ignoring the delay part, let my right be protected, my lord.
You were the respondent.
I was a defendant.
Yeah, I mean defendant. I'm sorry.
My lord.
You chose not to contest the suit by filing a written statement for whatever reason. Now, appeal also, you come to the court 4 years later. So, what is your conduct? You have not shown diligence at all. Promptitude and diligence which are necessary had it been affecting your properties materially, then you would have certainly jumped up to defend them. But you have not done that. Anyway.
Lordship may pass over the matter tomorrow. I will satisfy.
No.
Because 2 years delay, my lord, only 2 years, my lord.
Only 2 years.
Sir, I have to protect my property, my lord, because I will be injuncted from enjoying the land, my lord.
Heard Sri, you are SS Mahapatra. Heard Sri SS Mahapatra, learned counsel for appearing for the appellant. This is an appeal against order dated 14/3/2024, passed by the learned district judge Cuttack in RFA number 110 of 2023, whereby the appeal was dismissed on the ground of limitation. Stop. The appellant is the defendant, was the defendant in CS number 555 of 2017, which was decreed, which is 2017 in the court of learned civil judge, junior division, first court cutoff. Stop. Said the suit was filed for permanent injunction against the defendant, restraining her from coming over the suit land and from making any further construction thereon. Stop. Further, the plaintiff also prayed for mandatory injunction for removal of allegedly illegal construction raised by the defendant over the suit land. The defendant did not appear to contest the case despite service of notice. The suit was decreed. The suit was therefore decreed. The defendant preferred appeal before the district court. Before the aforementioned appeal before the district court. After a long delay of about 4 years, the first appellate court was not inclined to condone the delay, as the grounds urged to explain the same were not acceptable. Challenging such dismissal of the petition for condonation of delay, and consequentially the first appeal, the defendant appellant has preferred this second appeal. Sri S.S. Mahapatra, learned counsel appearing for the appellant, would submit that the appeal was preferred after a lapse of 1330 days. Stop. Such delay was properly explained by submitting a medical certificate which showed that, which proved that the had several arguable points to raise against the impugned decree, impugned judgment and decree. According to Sri Mahapatra, the first appellate court took a rigid view by not accepting the ground so urged, and refused to condone the delay, as a result of which the valuable rights of the appellant were valuable rights of the were interfered with. It is further submitted that taking advantage of the ex parte decree, the plaintiff has what were you submitting? What is the plaintiff doing?
Trying to take possession of my
He is trying to take possession over the relevant portion of the suit land. Having heard the counsel for the appellant and having perused the impugned order, this court finds no reason to interfere. This is for the reason that the ground cited for condonation of the delay does not in the least appear to be convincing. Stop. Be it noted that it has nowhere been stated that the defendant was prevented from preferring the appeal earlier because of any physical treatment. Rather, it is rather the ground urged is that she was undergoing physiotherapy. Apart from this, no other ground has been cited to persuade the court to treat it as sufficient enough to condone the delay. This court therefore fully concurs with the finding of the first appellate court that the appellant has not been able to show that she was prevented by sufficient causes in preferring the appeal earlier. This court therefore finds no merit in the second appeal so as to admit the same. The appeal is therefore dismissed. Yes.
Item 31.
The plaintiff is before your lordship against a confirming judgment. The plaintiff's case is, my lord, the plaintiff's grandfather, one Chandan Rai Mahanto, was in possession of the suit land. After him, the father, and thereafter the present plaintiff appellant. My lord, in the year 1987-88, a encroachment proceeding was initiated against the present plaintiff. In that, in 1990, there was an order for settlement of the land and matter was referred to the sub-collector under section 8A of the OPLE Act, holding that he is in possession on 88 more than 30 years. Thereafter, it was kept pending before the sub-collector. In 2013, another encroachment proceeding was initiated, in which I filed a show cause, which is exhibited, and stated that it is barred by res judicata because the previous set has been dropped on the ground that it will be settled. The learned trial court accepted all those documents, but said that it is not hostile animus and only 27 years have passed in the meantime. So it cannot, the adverse position will not.
No, just explain. You said that the matter was referred to the sub-collector for settlement.
Yes. Your lordship,
the settlement does not take into account the this 30-year thing. It is basically depending on the income of the person.
No. 8A says, OPLE Act 8A says that if my possession is more than 30 years,
okay,
then I'm entitled for settlement of the land.
Okay.
Subject to that, I should be a landless person.
That is what I'm saying.
Landless person.
Here, there has to be a report by the RI and all that.
The RI reported that. This Tahsildar passed that order. But unless it is confirmed by the sub-collector, the settlement could not be done. So it was kept with the sub-collector. He did not confirm the same. Neither it was reopened. It was also not reopened. If sub-collector suppose says that I am not agreeable to the report of the RI, then he will remand the matter with the remark that you re-inquire and pass necessary orders, and again it will be sent for confirmation. 2013, the second encroachment case was initiated. There, I filed my show cause that previously this order was passed, which has not been taken into account, and that proceeding was dropped. In 2019, I filed the suit, giving a 80 CPC notice. The court calculates from 2013, ignoring the 88 order. And if your lordship may see that exhibit, it is clearly stated, my lord. Exhibit 1.
Yes.
So I have framed the question of law at page 6, stating Roman 2 and Roman 1 and Roman 2. My lord, once that order referring to the sub-collector for settlement having not been challenged by the state, and in that report, it is clearly mentioned that more than 30 years our family is in possession. So by the date of the institution of the suit, it is more than 70 years.
When was that earlier encroachment proceeding?
87, 88.
87, 88.
87.
By that time, you were already...
More than 30 years. That is the report of the revenue inspector.
1 and 2?
1 and 2.
All right.
3 will also cover that, madam. If your lordship decides 1 and 2, 3 will be covered by that.
Lord Sri A.P. Bose, Learned Counsel for the appellant. Peruse the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. Page 6, 1, 2, 3. State is the party, isn't it?
Yes.
You accept notice?
Yes.
Sri Ardas Learned AGA accepts notice for both the state respondents. Two copies of the appeal memo be served upon him within 3 working days. Call for the LCR. Is this matter?
September.
Hmm?
September.
Ah, September.
23rd September.
23rd September.
But I have filed an IA.
What IA?
That status quo will maintain because I am in position of
Status quo with regard to the suit property be maintained till the next date.
grateful.
Item 32.
Your lordship may pass it over to tomorrow.
All right.
Item 33.
May I please, your lordship? My lord, the defendant is the appellant against a confirming judgment. Yes. My lord, the defendant is a builder firm. There was an agreement between the plaintiff and the defendant to raise construction B plus S plus 6th floor on the plaintiff's land provided by the plaintiff within a certain period. The next and half of the construction will be built up area will be allotted to the plaintiff. The next day, there was another agreement, supplementary agreement, where the plaintiff said that instead of my half of the built up area, you pay me 15 crores of rupees. 15.50 crores of rupees. 15.15. 15 koti 15 lakh. Admittedly, the time for construction, completion of the construction is not over. Admittedly, the time for payment to the plaintiff of this 15.15 crores of rupees is also not over. Within that period, the defendant has paid 2.80 crores plus 40 crores, 40 lakhs. Ultimately, 3.20 lakhs has been paid to the plaintiff. Before expiry of these two time limits, that is completion of construction or payment of completion of payment period, plaintiff instituted a suit, which was challenged by defendant filed his written statement. That suit is on various grounds. This suit is premature and other things. Ultimately, the trial court allowed this suit. None of the pleas raised by the defendant were accepted. And the appellate court confirmed. I have formulated the substantial question of law available to your lordship at page 174.
Can we just for a moment see the order of the trial court?
My lord, I have annexed it. Certified copy of the judgment passed by the civil judge.
So the suit was for declaration, recovery of possession, permanent injunction.
My
Just briefly look at the issues.
Page 204.
204.
204 the judgment starts. The issues are at 209.
My lord.
Issues are, my lord, page 209.
The plaintiff wanted to nullify that agreement.
Yes. Issues are available at page 209.
Yes, I've seen that. I just want to see the filing. So the suit was decreed.
My lord.
Decreed in full.
My lord.
What are the grounds you have urged?
My lord.
The grounds?
My lord, grounds are applicable at page 174, substantial questions of law. For that, in view of the respective pleadings of the parties, the Law and Trial Court framed as many as 8 issues. Issue number 1 is, as framed by the Law and Trial Court, whether the suit is maintainable. The maintainability of the suit was challenged by the defendant appellant on the ground of improper presentation. The plaintiff was not presented by plaintiff himself. It was presented by one of his authorized agent. And on the date of presentation, the authorization was not there. That I have challenged under ground number 1.
No, since the caveator has already appeared that I
Yes.
Fine.
Yes, I have it.
Both the caveators.
Both means?
Both means in the meantime, during the pendency, the original plaintiffs sold away the lands.
Okay. So
I am the original plaintiff.
No, so what I would, I find that this is not so much on factual aspects, rather it is purely on
law.
So I think LCR may not be necessary.
May not be necessary.
LCR is necessary, my lord.
LCR
is necessary.
Then I
my honest opinion, I will purely on points of law, but that point of law can be decided only on seeing the LCR. Some exhibited document.
All right. But then I'll have to admit it. I'll have to admit it.
No, my lord. I will place it, my lord.
No, how can I hear you at this stage?
My lord, yes. Once we have lodged a caveat, I have a right of hearing, my lord.
Right of hearing as regards the interim order?
No, my lord. On merit, on admission also. That is by the decision of the Supreme Court, my lord, by Justice A.K. Ganguly in division bench or whole bench, my lord.
What I was suggesting is that I will formally frame the substantial questions of law and fix a date.
But my submission is absolute. There is no substantial question of law. For the moment, let my senior finish. I will in only 5 minutes, my lord.
No. Time limit, there is no time limit. You can argue as long as you want, provided it is on the path. So let us consider, hear it finally.
A date may be fixed.
Short date,
my submission
since appeared through caveat, let us fix a short date.
Yes.
But my satisfaction, your lordship may kindly for a moment. Your lordship may kindly see page 200 for trial court judgment. Cost only I will take your lordship to the cost title. Nothing more. Defendant, my lord. It is there is no dispute that it is a partnership firm. And here the partnership firm is represented by its managing partner. There is no dispute on it. But fact remains, the development agreement was entered into by the landowner myself in favor of the partnership firm represented by Vibhuti Bhushan Patra. Lords may kindly appreciate. And this Vibhuti Bhushan Patra has expired on 29/4/2021. So, on his death, as per section 42C of the Partnership Act, my lord, the firm is dissolved. The firm is no more there. Furthermore, only as per your lordship knows, as per the contract act, only a living person or a legal person can constitute an agent. So a partnership under no circumstance can be an agent. So from the inception, the development agreement as well as the power of attorney was void.
Anyway, For that, I don't think LCR is necessary.
But for that, my lord, the way the grounds have been taken.
Let us do one thing. I am fixing a date to next week. Let us hear it.
My lord.
If LCR is necessary, I will call for it.
Yes, my lord.
Yes, sir.
LCR can come by special message.
Yes, sir.
Or both party can undertake to file the documents, exhibited documents.
That will be even better.
That will be better, my lord.
I'm okay, Devan.
All right, all right. Third and part. It is felt necessary to produce the lower court records at this stage. The court below is directed to transmit the LCR by special messenger so as to reach this court by 26th or by 29th, 26th of July. List this matter in the week commencing 29th at the top of the list. Part matter no approve.
Again.
29.
Week commencing 29th.
29.
It will come in the weekly list,
Yes.
but it will come as item 1, 2, 3. Part matters will come. We'll dispose of them.
Yes.
We'll dispose of. And I have seen that judgment of Justice Ganguly. I cannot say anything about Ganguly.
No, I think
Against a confirming judge. Well, there is no dispute that the preliminary decree was passed.
Is it a partition suit?
Partition suit. Preliminary decree was passed in which 50-50 share was given.
You challenge it?
No, that is no dispute. I challenge it. I have lost in the preliminary decree. Preliminary decree is closed. In final decree, there is no dispute that Athana Kismat Dijanaka branch or hela. That is not in dispute. When the Amin Commissioner went to demarcate and give the allotment sheet, there he did not put a fixed point. He did not demarcate properly. Neither he showed the position of the respective parties, which I have couched out from the evidence of the Amin Commissioner. I will just produce that.
But how can you challenge the final decree when you have not challenged the preliminary decree?
Preliminary
97 is a bar.
The preliminary decree was challenged, confirmed in second appeal.
Okay.
That 50% is confirmed.
You never challenged it.
I have challenged. I have given.
No, you said that I never challenged.
No. I have challenged that final.
Oh, you have challenged the preliminary decree.
So you lost. I lost.
Against that you have come.
No.
Oh.
I lost, confirmed in second appeal, holding that 50-50 will be there.
I think the same principle will apply.
No, madam. It will not apply.
I don't know. Enlighten me. If the appeal against the preliminary decree.
No, the preliminary decree is only a question of determination of shares.
Yes.
Final decree is question of determination of position of respective parties. My lord, I do not dispute that he is the owner of 50%. There is no dispute. Because I cannot challenge it because I have not challenged that before the Honorable Apex Court. When final decree, the allotment was being made, there I raised an objection that the respective position of the parties has not been done properly. And I brought out from the evidence from the, I marked that, your lordship may kindly listen. The commissioner categorically said that proper notices were not issued during cross-examination. Secondly, I have not taken fixed point. Thirdly, I have not verified the field position. I have not produced the measurement book and the maps before the court. This was the categorical cross-examination. I filed a detailed objection that on this report, the commissioner report is to be discarded. A new commissioner should be appointed. That was rejected by the learned.
You should have filed a CMP.
No, I can challenge in appeal also, my lord. If I don't challenge in CMP, I can challenge in final in the first appeal, taking all the possible grounds.
107, 104.
Yes, 104.
104.
I can take all the grounds in appeal. Even if my lord CMP I have
That's
gone.
true. That is the point. Also.
So both the court said that because commissioner has given and ignored the evidence of the commissioner, your lordship, I have marked those in yellow. He has categorically stated no fixed point was there.
So how did he do it? By triangulation?
Yes. He cannot do. He has
chain triangulation.
Yes. He has to do by fixed point.
Fixed point. That is the law.
Yes. This is the only point in this.
It's a very I think you must be very fully aware of it. There's a judgment by Justice G.B. Patnaik.
Yes.
The chain triangulation cannot be
accepted
by that fixed points which are in Baleshwar area known as Mustaqil Chanda. Mustaqil Chanda, isn't it?
Well, the first judgment of this kind, it was of my family. That's why I know it.
We say Mustaqil Chanda tha?
Yes.
Yeah. I think Mr. Das must be also aware of it.
I don't know that.
Justice G.B. Patnaik's judgment that you cannot adopt a chain triangulation method. You have to refer to the fixed points. And what are the fixed points also? Puruna Mandira, Pokhari, Gocho, Sabak map thibo. Mustaqil Chanda. Mustaqil Chanda si jo fixed point hota jo pillar hota pota jaye. Ironical, but we learnt to measure our land from the Britishers. Whether you accept
and one lawyer was there who could do this thing was late R.N. Panigrahi. He was master in this. And he was the commissioner who did our family partition. So I had the occasion of learning something from him.
So you challenge the final decree?
Final decree, the acceptance of commissioner report.
Just one doubt I have in my mind. You challenged the preliminary decree.
Yes.
You lost it.
Yes.
Thereafter, you never challenged it.
Yes, up to second appeal I challenged.
You filed a second appeal?
Yes.
You lost it?
Yes. I've given the certificate.
Then I think this second appeal will be maintainable.
If first appeal, after that I would not have challenged.
Then you could not have.
I could not have come up before.
That is what I was thinking, but I don't think while submitting you never said that you had filed a second appeal.
No, I didn't. I said I challenged in appeal and confirmed by the court.
So what are the substantial questions?
But I have framed the substantial questions of law in 1 and 2, my lord. 1 and 3 will do, my lord. Availability of fixed point I have taken and the valuation.
Heard Sri A.P. Bose, Lawyer and Counsel for the appellant. There is the impugned judgments. Considering the submissions and the grounds raised, the second appeal is admitted on the following substantial questions of law. 1 and 3.
1 and 3.
Page 6. Issue notice to the respondents, by registered post fixing returnable within 4 weeks, requisite to be filed within 3 working days. LCR be called for. List this matter.
Commencing 30th September.
In the week commencing 30th September. What IA?
IA for your lordship may say status quo because I am in possession of those lands which has been allotted in favor of the plaintiff.
All right, status quo with regard to the suit property as on date shall be maintained till the next date.
Because now execution has not been filed, so I cannot pray for the stay of execution.
Yes.
Can I get that document?
Please.
Item 35.
Also, can be taken up next week. Now, Mr. Rautre is seriously ill. He is suffering from fever.
Mr.
Rautre, Achyutananda Rautre. I'm appearing on behalf of Mr. Achyutananda Rautre. He is the respondent in this case.
Okay. Therefore, adjournment is made on behalf of Sri A. Rautre on the ground of his personal illness. Is this matter next week?
Next week, 5th August.
5th August. It will come in the 5th. Week commencing 5th August. Yes.
Item number 37.
My lord, item 36.
Yeah. Alinea
5th August.
Puri Jagannath Temple.
Yes. That was week commencing 5th September. 5th August.
5th August.
My lord, it has been adjourned. My lord.
Yes.
Oh, please.
37 I put the appellants. The suit for partition. During pendency of the appeal, respondent number 2, the appellant died. So entire appeal has been admitted. Since this suit for partition.
So LR sir need not be substituted.
They are not responding. You have given the letter.
All right, charge him. No. So, shall we say it is no instruction?
Since partition, one of the already should have been abated against the respondent to since long. So entire suit will be abated since that it is a for partition.
No, who died? Who died?
respondent number 2.
Yes, others are alive.
Others are alive, but I have written the letter. Now the letter has returned. Appellant has.
So that is what I am saying, no instruction. If the other respondents are there, how suit may abate against respondent number 2 only.
This is partition, intersuit.
So intersuit
It will be abated since there is no partition. It says died in the that order it's 27/4, 28/7/2004.
it is submitted that the respondent number 2 died way back in the year 2004. No such steps for substitution have been taken. So further, this is a suit for partition. As such, the entire suit abates. The appeal abates and is dismissed as such. Abate. Yes. What is it?
Item 38.
Your Lordship, a request for passover for the day. Item 38.
Item 39.
39 in the last occasion, my learned senior wanted a copy of the appeal memo I have handed over. Let it come up on Monday.
In
Because,
fact, I don't have that copy, I will collect.
Only collect.
You say you have to cooperate. Everybody has to cooperate. This is 2003 matters.
Yes.
You cannot keep it pending for long.
No, it should not.
Yeah, I'm giving time because it has come suddenly. So I'm just giving some time for you to prepare. So let us take it up. All right. As requested, list this matter.
29th July.
29 July. Chal. All right. 40.
Item 40.
Ready?
I'm for the appellant.
You are ready?
I'm ready.
All right, then begin. Begin. Let us begin for some time. We'll keep it partnered to next week.
Respondent नाते आओ दिन को आसु सर कहेंगे दी जन हेले दीटा एक संग सुन दो very short point reversing judgment 1 point only.
What is that point?
Yes.
Just tell me. I'm not opening my file. Just tell me what is it.
My lord, whether a third party in this property by virtue of an earlier sale will get into the property.
Okay.
That is the only point.
We'll hear it tomorrow.
ଆଉ ଏଇ ସପ୍ତାହ ରଖନ୍ତୁ ନା ସାର୍
ନାଇଁ ଏଇ ସପ୍ତାହରେ କାଲିଠୁ ଏଇଠୁ ଆରମ୍ଭ
ନାଇଁ ସାର୍ ଗୋଟେ ସପ୍ତାହ ପରେ ରଖନ୍ତୁ
ନାଇଁ ୟୁ ଆର୍ ଦି ଆପେଲେଣ୍ଟ ଆପଣ କଣ whether the respondent is present or not how to matter
commencing 5th August ଆସୁ ସାର୍
କାଲି item 40 ରୁ ଆରମ୍ଭ ହବ
ସାର୍ ଅଲଗା ଅଲଗା କନସିଡରେସନ ତ ଆସିନି
I will make it partnered. I'm not saying I'll complete it.
No, 5th August को आसु सर कर देबी I'm ready.
On basis matter we commencing 5th August.
Interim order may be extended.
Interim order to 41 onwards. काली को आरंभ हो. Yes.
Sorry, my lord. Item 42, my lord, no instruction. I am for the appellant.
Item 42, no instruction. Dispose of. 41 to काली आरंभ हो.